Justice of the Appellate Division for Courthouse. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. The first case for argument today on the calendar is number 505, People versus Sean Smith. Counsel for the appellant is remote. You may proceed.
May it please the court, Lyle Hoydu for Sean Smith. Smith was 14 years old when he was convicted of robbery and felony murder. He was sentenced to an aggregate of 9 years to life. This is his application to be resentenced under the Domestic Violence Survivors Act. To get to the point before I lose my voice, we agree with the court's finding that this 14-year-old boy was exposed to physical, mental, and emotional abuse. There was no question about that. He was beaten by his father, who was later imprisoned for homicide. He was beaten and neglected by his mother, who abandoned him. He grew up where violence was the norm, and it led to gang life on the streets. Where we take exception is when the court found that it was not a significant contributing factor for his violent behavior.
Counselor, can you back up for a second then?
Yes.
Concerning the, you're indicating that he had a history of being beaten by his father. And I'm looking at the pre-sentence report, the investigation there, and the defendant denied any physical or sexual abuse issues in the past, although he did report being struck in the buttocks with a belt, which he did not consider physical abuse. So then 20 years later, he claims that he was beaten regularly by his father.
That's correct, Your Honor. Later on,
It appears that more recent in the time that the criminal proceedings were taking place, that he felt he was struck in the buttocks with a belt a few times. And that does not sound like as drastic as he's making now during the time of the hearing, where he's seeking this reduced sentence, where he indicated now he was beaten rather regularly.
The one thing I would point out is that it's very difficult for a child to document and explain past abuse and behavior and to hold them to the same standard that we would have as an adult. And when you look at this 14-year-old, we know he had exposure to lead poisoning. He had a very low IQ. He was in the special ed program. He was emotionally disturbed.
I'm not sure. Well, I do not think that those lead paint poisoning factors of that nature are relevant to resentencing under Penal Law 16.12. It's physical or sexual abuse as a child, but let's grant you that his father beat him as a child. Let's grant you that.
But isn't it also the psychological abuse and the emotional abuse that he had to go through as a child? He was only 14 then.
It is, Your Honor. And just to back up for a moment, I raised the issue of the lead poisoning, the low IQ, the special ed student. Explain why he does not articulate in greater detail as to the past abuse that he suffered. In fact, he grew up in an environment where the past abuse was normalized. So to expect a 14-year-old to be able to document in a PSI all the past abuse he suffered, I don't think you can hold that child to the same standard. That's why when Judge Montour asked me why, as an adult, he's bringing up additional information, I think it's because a child is disadvantaged. And that's an unfair standard to hold the children to that same point.
Right. Well, let's say he was beaten by his father. His father was incarcerated for a homicide when your client was 9. this crime, the murder that your client committed was when he was 14. The people say that's not at or about the time of his instant offense as required by the statute. It doesn't require it to be instantaneous, contemporaneous, but there has to be some temporal nexus is what the people argue. What do you make of that gap, that at least 5-year gap?
I don't dispute the timing of it, Your Honor. It's just that if anything, it makes it worse because it demonstrates that he was not exposed to an isolated incident for a period of weeks or months, but the abuse that he suffered went on for years. And even after the father was incarcerated, he was subject to that physical and emotional abuse in the home with his mother. Physically,
Your client has been released. He's been out of prison for 4 years now. And resentencing now would not change his custodial status. He's on parole. He has the life at the back end there, but his custodial status wouldn't change if the application is granted. Is that not correct?
that is
He's already out.
correct.
I know he probably doesn't want to be on parole, but he did murder somebody and rob somebody else. And there's a way to get off of lifetime parole. There's a petition for good behavior, you can petition the parole board to try to get off after a period of time. But it doesn't, most of these applications, somebody is in prison and they want out. He's out and he would stay out even if we agree with you.
Understood. You bring up the remedy part of it, and that was never raised at the trial level. That's why it was not addressed in the briefs. But I have to acknowledge that certainly is a legitimate issue in terms of what to do now that after he's been released.
Counsel, the disconnect that I perceived from the decision was related to the victim in this case. The victim in this case is not the abuser. Victim is a third party, and that's somewhat unusual under the DVSJA case. Most of the time, you have the act committed against the abuser or someone very closely related to the abuser, somebody with the abuser, perhaps. In this case, you have a disconnect. You have this essentially non-party woman on the street that's just, sort of following him, chasing him, I guess, with respect to a vehicle after he committed the robbery. How do we extend the DVSJA to that type of a victim?
Well, the statute itself does not require that the abuser be the victim. So the statute doesn't require it. The Court of Appeals just issued a case. It was People versus NH. It's a slip opinion, 2026 New York slip opinion 02437. And in that case, the victim is not the abuser.
Right, you're definitely correct. Under the statute, the victim, the person that your client murdered doesn't have to be the person who abused him. It can be some innocent random person like here. But I think what Judge Noack might be getting at is that to meet your client, to meet the burden of it being the abuse being a significant factor, it's a lot easier to prove when the person you kill is the person who abused you. It's a little harder when you just have some random woman who you don't even know and you shoot her in the head. That you can get it, but the burden of proof may be a little bit higher to show causation.
I would acknowledge that, Judge Noack. I misunderstood your point. I'm sorry. Yeah, I definitely would acknowledge that. When you have the link between the abuser and the victim, it's easier to understand. It's harder in a case like this.
In a case like this, does it require an expert? Does it require a psychologist, somebody that can make that link and say, this is why abuse by person A is related to then an act against victim B, person B?
I've seen other applications when that was exactly what they had done, is retain a psychologist so that that person could demonstrate that link. With what limited facts I had, I cited that when, and this appears in the sentencing report, which I presume came from the police report, is that this woman pursued and cornered the 14-year-old and then told him not to go anywhere because the police were coming. And that created a stressful situation that led to the fight or flight response. Certainly would have been better if that were coming from a professional in the field that would do a more in-depth analysis, but I think that's the argument, Your Honor.
All right. Well, thank you for your argument.
Good morning, Your Honors. May it please the court, Harmony Healy on behalf of the people. I'm not going to linger on whether or not this was substantial domestic abuse. I'm not denying the cumulative effects of child abuse and child neglect, and I understand that there is a temporal nexus requirement, and I will rest on what I argued in my brief with respect to that part of it. I think where I'd like to focus my attention on is whether or not this was considered a significant contributing factor. And just to go back to what you just said, Justice Nowak, when you're talking about whether or not you need an expert, I don't know that you need an expert, but you do need somebody to make that link. And in this case, nobody did. The defendant submitted an affidavit. In the affidavit, he didn't discuss what happened at the time of the crime. He only talked about his prior child abuse, and he talked about the fact that he was youthful at the time and that this was hard for him. And with respect to what my opponent just said about triggering of flight or fright response, that is also nowhere in any of the paperwork underlying this. And so I understand that it doesn't need to be under the law, under the case law. It doesn't need to be the person who was the abuser. It can be a third party. But when you're drawing the significant contributing factor, I think you need to look at the evidence that was before the court, and somebody needs to make that link, and no one here did. In fact, in her attorney affirmation, defense counsel at the hearing said, "We don't know what was going through his mind when he pulled out the gun. We don't know whether he was scared. It might have been tremendous fear. But whatever it was overwhelming enough for him to pull the trigger." So with no evidence whatsoever that this had any effect on his decision-making at the time, I don't think that the court did anything wrong by not getting there. Yes.
The argument about being cornered, this whole idea, was that really made? It seemed that the argument below was more about the intoxication that the child was under, again, perhaps because of the years of abuse, but that was sort of the avenue pursued.
Yeah, and that's my understanding at the lower court. I'm just mentioning this because that's what he had mentioned in his underlying brief and just now. And so I think that in this case, the causation part, or the significant contributing factor part, is missing. And then I also think that when you're looking at the unduly harsh prong, one of the things that you should look at are the facts and circumstances of this case. And
The trial court didn't get to that prong, right? The trial court denied it on prong 2. So if we were to disagree with you on prong 2, would we not remit for the court to make a determination whether it's unduly harsh, or should we just make that on our own?
So I believe you can make that on your own because it's a 3-step analysis. And I think in People v. Wendy BS, they were, and I believe that was Judge Nowak may have been on that panel. You did move to the unduly harsh prong when only the significant contributing factor prong was discussed. And so I think that you can reach that.
Do we look at, and I don't know the answer to this, but if we get to prong 3, unduly harsh sentence, do we look at the sentence at the time it was imposed, which was, or do we look at it now? Now he's already out.
Well,
All he's talking about is supervision now.
right.
Is it unduly harsh for him to be supervised? Whereas do we look at it at the time of the actual sentence? Different matter.
I think that you look at it now, partly because the statute imposes that you have to be incarcerated at the time when you're making this application. And I think that is because when people are released, it's a totally different situation. And you're talking about releasing somebody
He
who
was incarcerated. He was in custody
at
at the time of the sentence, and he was 14, and he did 21 years before he got out. So But wouldn't we look at it at the time that it was imposed?
I think
And
he
he
got
still
the,
got life on the backside.
well, yeah, of course he had life on the backside. I understand. And you're looking at the sentence when it was imposed, but currently right now he's not incarcerated. He is out on post-release supervision. And I think that one of the things that you have to consider is whether or not it's going to pose a danger risk to public if you release him at this point. And the fact that he was incarcerated for 22 years when his minimum sentence was 9, I think that that's a consideration. He was incarcerated for way longer, which implies that he had some behavioral issues while he was in.
Is there any evidence? Because you're right, he got 9 years to life. I think for shooting somebody in the head and murdering an innocent person, that doesn't seem terribly harsh, but as Justice Ogden indicated, he did over 20. Do we know, is there any evidence in this record why he kept being denied parole? Was it anything, his behavior inside?
I'm assuming it was because they don't normally keep somebody that.
But is there any evidence in the record of misbehavior reports or anything like that?
The only thing that's in the record that I noted was that he had been sentenced on his promoting prison contraband while he was in. So there obviously was some behavior issue. And I think that this is a person that needs to be supervised, and that should be one of the things that you're considering when you're talking about whether or not it's unduly harsh. And that is something that they considered again in Wendy BS.
Right.
And if there's no other questions, I will rest my brief.
Thank you. Go to case 507. It's People versus Daniel Murray Adams, 507. The people have submitted, this is in line with our last case,
Yes,
similar issue.
yes. Good morning, Your Honors. May it please the court, Molly Perlman with Hiscock Legal Aid for the appellant Daniel Murray Adams. This case concerns whether the protections of the DVSJA will be meaningfully applied where the statutory criteria were established by the preponderance of the evidence. On the outset, I want to briefly address the framework advanced by the respondent in their brief. The question before this court is not simply whether or not the county court abused its discretion in denying DVSJA. Under Brenda WW, this court is empowered to conduct a plenary factual review and substitute its own discretion where the record warrants relief. Here, the unrefuted evidence shows that Daniel endured profound abuse and psychological trauma throughout his formative years, that those experiences fundamentally shaped his responses to stress and perceived danger, and when confronted with circumstances mirroring the trauma that he lived through since infancy, he reacted from the trauma. Therefore, the court.
Counselor,
Yes, Your Honor.
you don't disagree that there were years between the offense here and the trauma that you endured.
I do in part. That leads me to, I wanted to correct a factual assertion in the respondent's brief. They stated that my client was not living with his mother at the time of the offense. In fact, he was, and he had for several months. And so he was
There's a little
still.
bit of an issue in the record on that. He testified he moved out, and I think it was his wife's letter is what you were referencing, that he was still living with his mother.
Well, he testified that, yeah, he moved out at 20.
But nevertheless, even if
Oh.
even if he was living with his mother, he wasn't suffering the tapes and any abuse while he was living with his mother, was he?
Well, that's where we differ in that the legislature included psychological abuse in the statute, and we submit that he still was experiencing psychological abuse. He was still living under her roof, living under her rules, under her influence, still in this warped mindset that CPS is will ruin a kid's life. And then when he was faced with the real possibility of a similar traumatic situation happening to his child, as happened to him when he was a baby, being ripped from the arms of his father, that was a trigger. And that's something that is spoken about in People v. Alexander, this idea that childhood abuse, whether or domestic violence, whether witnessed or experienced as a child in your formative years, can establish that prong of substantial abuse. And then other cases, such as People v. Mitchell, and the Second Department has embraced this idea that PTSD from this psychological abuse as a child is ongoing at the time.
His claim is he was ripped from his father's arms when he was a young boy, right?
As a baby.
As a baby.
Yes, Your Honor.
When the police were involved somehow. And then 20 years later or so, he cuts this man's throat because he fears CPS is going to come take his baby. The man who has cut his throat was not trying to take his baby. He was trying to help his baby, as a matter of fact.
I'm sorry.
And so I get if CPS or the police are coming to take his baby, maybe there's a trigger. The victim here was not a threat to his baby. And yet he could have easily just slit his throat and almost killed him.
Well, a couple things on that is he actually, the testimony, the unrebutted testimony shows that the man wasn't trying to help the baby. He was wielding a baseball bat, walking towards.
See, this is the problem, is that we were on the appeal of your client's convictions. He testifies here about a story that is not consistent with what the evidence was on the appeal. So I don't know how we deal with that. Do we just accept his testimony here?
Well,
Can we take judicial notice of our own files? Because as I said, his story here is totally, it's not even close to what the evidence was at in the prior appeal.
we would just ask for this court to rely on the record. Anything could have been brought up in the DVSJ hearing by.
Well, there is a record, because counsel, I don't think you referenced our prior decision. And including the fact that another panel found that the sentence was not harsh and unduly harsh and severe. That's not referenced.
Right, under the typical direct appeal, harsh and severe, but that's.
On the facts that were presented to a prior panel, that court concluded that. Drew that conclusion. You don't reference that at all in your brief.
No, I admittedly focused on the prongs within the
Right,
DVFA
Your
statute.
position is, when we looked at it last time, it was the sentence imposed at the time harsh? Now we're looking at it through a different lens. He's made progress years later. We look at it differently now than we would in a typical harsh and excessive.
Yes, I would submit that we do the court should look at it differently now, especially considering the framework that is set up by the legislatures in this DVSJA statute, that a trauma-informed lens, considering, a lifelong 2 decades of psychological and physical abuse, look at it through that lens, that this isn't, a man who has years and years to heal from his trauma, heal from this secrecy that he was living in.
He could have gotten 25 for this.
I'm sorry?
He could have been sentenced to 25 determinate
Yes,
for
Your
his
Honor.
crime.
He
He
could
got
have
15.
He could have been sentenced to 5 to 25. I'm sorry.
Right, he could, 5 to 25.
Mhm.
He got 15. Now, if we grant him this relief, the max would be 5, it'd be time served.
Yes, he has.
Numbers we're dealing with.
Yeah, those are roughly the numbers that I have, that he served, about over 10 years, or I'm sorry, over half of his sentence. And that we submit that if we're looking at the third prong as well, that it should also be taken into consideration that all that he's been through while incarcerated, while finally being away from this abusive influence of his mother, he's taken advantage of voluntary programs. He not only would be, safe to re-enter as he had the community, as he has been rehabilitated, but he would actually be an asset to this community. He's shown that through working with youth while incarcerated. He has a unique position of experiencing a lifelong of, childhood abuse, that he could help people. He's already started to help people. And that he has worked hard to navigate his trauma in order to be rehabilitated. And that's important in this third prong.
What if he fails on prong 1 or prong 2? We don't even need to get to prong 3. Isn't that correct?
Right, yeah, if he fails on any of these prongs, you would not need to look further, but we think that there is value in it, and there's value in giving Daniel the treatment that he may, receive, say, if he was a young girl going through this abuse, that young men in this country, specifically young Black men, are not afforded this childhood, free of constant abuse and situations that don't prepare them for triggers such as happened on that day in June. That looking at the case with the entirety of everything that he had been through, that he could not navigate that situation. That does not excuse his behavior, and he has taken accountability, he's pled guilty, and he spent a lot of time viewing
And
this
also a
trauma.
factor, I think he had a order of protection. The mother had, and he was in her apartment,
Right, so,
child, so there could be that prospect of being facing a violation of this temporary order of protection, even though she wasn't there, but wasn't that his rationale too for running upstairs?
yeah, I think it's important to look at that specifically, that here he has, through CPS involvement, he has an order of protection, he's not allowed to be there, and he has what was lowered to a B order of protection against the older son. Older son was not there. The mother of the child, of all of the children involved, requested Daniel to come to her house to.
That's not a defense.
No, it's not an offense, but it is important to note that the mother of the children clearly was not concerned
If there's
of the
order of
safety
protection against your client on behalf of his own children,
on behalf of
one
the older child
child for what?
Discipline.
For abuse. So the statute, your client who allegedly was abusing, he was an abuser himself, apparently. And now he's trying to take advantage of a statute because he was abused. But I guess, you would say, well, that's just a cycle of abuse. Somebody gets abused, so that shouldn't disqualify him, but it does seem a little odd.
I mean,
He's violating order of protection, is now reaching out for protection as somebody who's been abused.
I would just submit that courts have found, and all we know about psychological abuse and childhood abuse, is that a trauma-informed lens looking at this situation is that the person being a quote-unquote abuser himself, even in the commission of the crime, does not disqualify GVSJA consideration. It does not make the person not a victim of domestic violence. And that it actually he was, recreating some of the experiences that he himself has as a kid. And then once that was pointed out, he went to parenting classes. He was, working on things, but then being put back in his mother's house under her rules, under her influence. CPS will ruin your family. We submit, and he testified to that this idea of his protecting his son was paramount and was a significant contributing factor in him fleeing, in him blacking out, which is something that he did experience as a kid. He had these blackouts when he was triggered, was prescribed medication, mood stabilizers that could have helped him in this exact situation, yet that was taken away from him by his mother.
I think we understand the argument. We thank you for it.
Thank you.
Next case on the calendar is 509 People versus Darius Cadenhead. 509.
Thank you, Your Honors. May it please the court, Harmony Healy on behalf of the people. The lower court erred in suppressing evidence that was obtained from a level 3 safety frisk because the officers had reasonable suspicion to approach the defendant and it was not a patent violation. So first, just briefly to talk about the patent violation. I think that the lower court erred in determining that this was a facility, that this was a secured building. And I think that the lower court also misinterpreted the fact that there were some doors that locked leading into the apartment complex, but there was also an open door that leads into the apartment complex from a restaurant. And so I think that the lower court misinterpreted the testimony that came out. One of the officers testified that he had arrived all at the same time as the other officers, and that the door to the brewery was open and they were just able to walk right through.
Even if it was not open to the public, there's case law that says there's no expectation of privacy there for patent purposes if you're arrested in a common area of an apartment complex.
Correct, Your Honor. And I think that what you're looking at is the expectation of privacy that it is with the other tenants and their invitees. So
Let's get to the harder issue, perhaps.
Sure.
Was the initial intrusion a level 3 intrusion, justifying a detention? Or was it level 4 where they needed probable cause for an arrest?
So I think that it was level 3. The Lieutenant Wozniak testified that they had initially intended on going there to talk to him. And then if they weren't able to get anywhere, they had planned on arresting him. But even if they had planned on arresting him, ultimately, it's not the subject intent of the officers. It is the actions that are taken and what's justified that you're looking at. And here they had, I'm sure you're very familiar with the record, but they had the surveillance video from the apartment complex in Jamestown, where the defendant had gone in with the victim on January 22nd, and the defendant left later on January 2nd. The victim did not. The victim never left his apartment again alive, and no one else had gone in the apartment.
What about that time lapse on that video that has been lower court paid little attention to?
Yeah, so I mean, I don't think the time lapse has that huge of an impact because he testified that he thought it was 8 hours off, and I think that they accounted for that when they were talking about the time. I don't think it was as important as was made by the lower court.
If the court believed it, if the court believes that part of the testimony of Officer Wozniak, would the timestamp have mattered at all?
I don't think so, because it was such a significant amount of time that had passed between, and the court did indicate that he believed that the identification and all of that surveillance video and everything was coming in, and that it was the defendant that they saw. So he stated that on the record in his decision. But I think that the timestamp and all of the rest of the stuff, in terms of just a suppression hearing, I think was enough to get us past that hurdle.
Are you arguing that that video gets you to level 4 or level 3?
That would be my alternative argument. I think it gets you to a level 3. And I think that when they stopped him and frisked him, did a pat frisk, I think that was a level 3 detention. That is.
Well, the problem from the video, when you say it was just a level 3 and you need reasonable suspicion rather than probable causes, you have a guy with an FBI looks like an automatic rifle pointed at the defendant's head with a red beam on his head. You have other officers with guns drawn at him. Hard for me to see how that's not an arrest at that point in time, regardless of whether they wanted to talk. They obviously wanted to talk to him. That's why they didn't get an arrest warrant. But when you accost somebody with that type of firepower, seems like an arrest.
Right. And I understand that, but I think that there was reasonable fear that he may be armed or that he may be a flight risk. And I think that some of that is borne out on the record. They knew that there was.
But wasn't he checking in regularly with his parole officer? How would it be that he was a possible flight risk?
So
and they knew where he was.
They knew where he was, but I think even when he was leaving his apartment, he had like a cart that he was pushing that had his belongings on it. And so I don't know if that has any, potential bearing on whether or not he was a flight risk. But I do also think that there would have been enough for probable cause to arrest him. That alternatively, I would say that I think you have at least enough for a reasonable suspicion, but I also think that you have enough for probable cause. The fact that this person entered the apartment and the victim never came out alive and no one else went in between that amount of time should definitely give you at least probable cause. And I know that.
And there was never a weapon that was found within this 3-day period. I mean, it's obvious that this victim was shot in the back of the head.
Shot in the back of the head.
So this weapon hasn't been found. So, I mean, could this, what we saw in the video be some precautions that these officers are taking at that time, because we don't know if he's still armed.
We don't know if he's still armed. We don't know.
He's a prime suspect.
He's the prime suspect, and they know that he's on parole for prior manslaughter. So there's also that.
I look carefully at that because that does seem kind of probative. He killed somebody before. He's on parole for it. I believe the testimony was the Lieutenant Wozniak and the others knew he was on parole. It's not established that they knew what he was on parole for. They didn't testify to that. They probably did know it. His parole officer knew it, but they have to establish that at the hearing. But you have the video evidence that shows that he went into the apartment with the victim approximately 2 days before the body was found. Nobody else came in or out until the neighbor came in and then found the body. You have the fact that he was on parole, the defendant was. You have the fact that the defendant didn't give his complete name to another officer when asked earlier. You have the fact that the defendant didn't answer the door when police said they were there for utility company or whatever. Those things aren't much, but they're not nothing.
Right.
You add those up with the video, is it more probable than not? Like not beyond a reasonable doubt, just more probable. The only two people in this world who could have done it was the person who found the body or the defendant. It seems a little more likely that it'd be the defendant than the guy who actually called the police when he found it. That doesn't seem to be great, criminality. Like you're going to get caught with that. So I don't know. It seems a little more likely that way to me.
Yes, and that's exactly my argument. That they had at least reasonable suspicion, and it was a level 3 detention. If not probable cause, I do think they had probable cause, but I think that yes.
If we're gonna disagree with the court who conducted the hearing, looked at the witnesses and all of that, I mean, normally there's deference there. If we're gonna do that, where do we do that? Where do we find that the court erred in terms of the court's evaluation of that same evidence where the court didn't find probable cause?
Well, so I think that the court kind of took a misstep on the Peyton issue, which means that he was not only requiring probable cause for the arrest because it was a warrantless arrest, but he was also requiring exigent circumstances. And so I think that's where the court took a wrong turn. It wasn't just that he needed probable cause, he needed probable cause plus exigent circumstances to effectuate an arrest in his home. But this wasn't in his home, it was in a shared tenant hallway.
But the court didn't find probable cause either. I mean, so do you think that that's just like, that sort of like poisoned the judge in some way, or that the judge was just affected by that other ruling that didn't really give a careful look at the probable cause issue?
No, I think that he again had the problem with like the timestamps of the video, but then ultimately said it was the same individual. But I think that there were a couple of missteps that the court took. When you're evaluating probable cause, I think that's illegal. You're marshaling the facts and then determining if it's enough legally to meet that threshold. You're not talking about credibility determinations because you really didn't make any credibility determinations. So I think the deference goes to the credibility, but that's not what this is.
Court seemed to place heavy emphasis on the timestamp discrepancy, which I don't get how that has any relevance at all. As long as they watch the video, who cares if the defendant and the victim went into the apartment at 8 p.m. rather than noon? As long as they watch it continuously, we don't care about the times.
Right.
And that seems to be.
Days, and so someone else could have come in.
I think that how you know it's not
might
off.
not have been the only one.
You know it's not off by days because the officer testified that he had looked at his watch and looked at the time and figured out from when they were playing the video live, they were able to figure out how far behind it was, and that accounted for the timestamp issue.
If there was a gap in this viewing, then we got a problem. 8-hour gap, somebody could.
Right.
But my understanding, correct me if I'm wrong, the police officer said they watched from the moment the defendant went into the apartment with the victim continuously until the body was found. No gaps.
Correct.
And that was a 2-day period.
Correct.
Or whatever day period it was. Could have been 2 hours, whatever it was, it's kind of incriminating.
Yes,
Timestamp mistakes or not.
right. And so if there are no other questions, I would rest on my brief. Thank you.
Good morning, Your Honors. Leah Farwell for Respondent Darius Cadenhead. Just to get into the surveillance footage issue, I agree entirely with Justice Ogden that we cannot be sure that it's not off by days. We have this vague testimony that it's 8 to 12 hours. However, that testimony ignores the fact that not only was the body discovered by one other person with a key, there was another person with him as well. And just to go to the reasonable suspicion argument, reasonable suspicion requires a quantum of knowledge sufficient to induce an ordinarily prudent person that criminal activity is at hand. The appellant in their reply brief points to 3 articulable facts that attempt to justify reasonable suspicion. None of them are sufficient and pose more questions than they answer. First, the first fact is that the victim was shot to death. This is the barest fact necessary to begin a murder investigation, but there was no autopsy. Time of death was never established prior to the Jamestown police going to arrest or speak to Mr. Cadenhead. There were no eyewitnesses, no DNA analysis, no ballistics, no weapon or fiber attaching Mr. Cadenhead to the crime. The next articulable fact is that they had knowledge that he was on parole. Once again, this is based on this unauthenticated surveillance footage that the hearing court did not even consider. The appellant, I think, cites this parole knowledge in the hopes that the court will be persuaded that this knowledge, coupled with other equally weak facts, will justify a level 3 stop. However, if the investigation were so strong, why didn't the police contact Mr. Cadenhead's parole officer and request an interview that way? It would have been rationally and reasonably related to their duties as parole officers. Instead, they chose to initiate 2 other police agencies, the FBI and the Buffalo Police Department, and go to arrest Mr. Cadenhead, which 2 officers testify that their intent was to go there and arrest Mr. Cadenhead. Their intent was not merely to talk to him. 2 officers testify that they intended to arrest him.
Well, I think they wanted to arrest him and then interrogate him. Is what
Exactly,
they wanted to do.
Robin. And if they did go there with just the intent to speak to him, I think we have a Shaw issue where they were going there to speak to him before his right to counsel attaches. And we can only speculate on that, but I
How
think
is that a problem? Doesn't it happen 98% of the time that the police forego getting an arrest warrant so the right to counsel doesn't attach?
the Shaw decision does say that this indicates that the police would have every reason to violate Peyton because doing so enables them to circumvent the accused's indelible right to counsel. And I think that is, I don't want to speculate, but I think that is what happened here. So going back to the third articulable fact that they cite is that the gun was not recovered. This does not specifically point to Mr. Cadenhead. And it does not, there was no ballistics testing. They wouldn't have even known if the gun that was recovered from Mr. Cadenhead would match the murder weapon.
Could we go back just for a second regarding the watching the testimony that the officer gave about how they watched that surveillance video continuously the whole way? I was under the impression that perhaps the judge didn't believe that testimony, because if you do believe the testimony, it's my understanding that you'd have to find probable cause. So I thought the issue might be, did the judge overlook it or did the judge not believe it, which I think matters a great deal. And is there a third option here? Are you claiming that even if the judge believed they watched it continuously, that still doesn't rise to the level of probable cause?
Lieutenant Wozniak testified that he did not watch the entire cache of footage, and that is cited in the main brief. I apologize. I do not have this specific piece of testimony in front of me, but he did not watch the entire cache of footage.
All right, so it's not about believing testimony. In fact, he didn't testify to it.
Correct. Yes.
Testified
It's the
somebody, the police watched it. not necessarily him personally, but somebody from the police department watched him. Right? So maybe that's not true. Maybe the judge didn't believe it. I don't think the judge discredited that testimony. Again, I thought the judge was not finding probable cause, not because they didn't believe that somebody watched it, but the timestamp issue seemed to really be his main concern.
Yes, and it's because it was not authenticated. No one ever came and said, you know, this is however you authenticate video footage. No one ever came and did that.
Is authentication required for the police to get probable cause? Or is that a trial admissibility standard?
I think it's a trial admissibility standard, but if the court is relying on it to find that there was or was not probable cause, then it seems to be important here.
Okay.
So Mr. Cadenhead argues that there was no probable cause here and that he was either arrested or de facto arrested the moment that he was that he stepped outside of his door. And I would just like to point to a comment that Justice Lindley made. Guns were drawn, 3 agencies responded. There were no less than 10 police officers who were there to ostensibly talk to Mr. Cadenhead. According to them, according to them, they just wanted to talk to him. Why did they need 10 police officers there to talk to him?
A pretty serious offense, don't you think?
And they arrested him and then they talked to him. It's not like, hey, we want to talk to you about this. And no, handcuffs at gunpoint, take him away. It just doesn't seem, tenable that this was anything but an arrest.
Yes, Your Honor.
Which makes the people's burden higher.
Yes, and it was the people's burden to prove, and it is my assertion that they did not. There were forceful and intimidating verbal commands that the FBI officer ordered him to turn around and to face the wall, slowly place his hands behind his back, and he was handcuffed. And at that point, he was frisked. And he was completely at the mercy of these 10 officers, these 3 agencies. He was not a flight risk. That basket that he had, it was a cart with his laundry. He was going to do his laundry.
He hasn't been charged in the murder as yet.
No.
We're just talking about the weapon he had on.
In Chautauqua County, I believe he has been charged, but it is being held in abeyance of the suppression decision.
He has been indicted on murder?
I don't know if there is. Last time that I spoke to him, I believe that there is an active indictment and it is.
Well, it's not relevant to our determination.
Correct.
Right.
Correct.
All right. Well, we thank you for your argument.
Thank you, Your Honor.
Case number 510, People versus Shazir Courier. Case 510.
Morning, may it please the court, Sabrina Bremer on behalf of Mr. Purrier. Today, I want to focus on the suppression issue. County court applied the wrong legal standard when evaluating the legality of Mr. Purrier's forcible seizure. Because the troopers prolonged the traffic stop and immediately handcuffed him and attempted a pat frisk, they needed reasonable suspicion to justify their actions.
Reasonable suspicion to believe the defendant was armed and dangerous, not reasonable suspicion that they may have committed a crime, right?
Right.
Big difference in this case.
Yes, and there's no testimony that they believed he was armed and dangerous. Trooper Manley testified that he made no sudden or furtive movements. He was not behaving erratically. In fact, he complimented him on how cooperative he was behaving. So there was.
When did the detention take place? When they put the cuffs on? Or when he asked them to get out of the car?
I think that a stop of a car is considered a seizure. The forcible detention starts.
Well, you got to stop. You're not arguing the stop was unlawful.
No, the stop was not
unlawful. You got a car stopped on the side of the road with 2 troopers coming up to the car to give detail. And when in your mind was your client detained?
So they're detained as soon as the car is stopped, which they're allowed to do because of the traffic infraction.
That's lawful. When is the unlawful detention, I should ask?
When they prolong the traffic stop to conduct this further investigation into the probable search of the car. And that is addressed in the United States v. Rodriguez, where officer safety interests are very different from criminal investigation. They cannot just prolong a traffic investigation without reasonable suspicion, even if that initial stop was legal.
And the prolonging here really didn't take all that long because the initial stop is just for the tinted window violation.
Right.
It doesn't take that long to write a ticket for that or whatever you're going to do.
Yes, but they did not write a ticket for that. They stopped the car. They don't have a tool to measure the tint of the window. The driver shows his license. There's no testimony that there's any issue with the license itself. And the troopers are immediately, almost, I would say, a fishing expedition, trying to find a reason that they can prolong this detention, conduct a search of the car.
Well, seems a little simpler to me than that, in that the trial judge said, which is true, on a lawful traffic stop, the police can order occupants out. Just on a traffic stop. No other case called Garcia says that. Robinson said it back in the day, Court of Appeals. You can order somebody out on a traffic ticket as a precautionary safety measure. That's well and good. What happened here, Trooper admitted, he ordered him out and immediately handcuffed him. That is, you can't even pat frisk somebody under order them out. You need to pat frisk, let alone to handcuff, you need more. So they need some reasonable suspicion that there's a danger, there's a weapon. Here, the only evidence of a crime looked like we had that traffic violation, but wasn't against your client, it was the passenger seat. You had the pill box. You had a pill container, right, with no label on it. That's not a safety concern, but it may be a crime. What this seems to come to is that so it was unlawful in your view to just handcuff him immediately, and it made clear on cross-examination he was immediately handcuffed. That's not lawful.
Yes, absolutely.
Before the weapon was seen by the other trooper.
Yes.
He was handcuffed beforehand. But the people would say, well, we had probable cause based on the pill container. Matter of fact, the officer on the other side of the car explicitly stated, we have PC, go ahead and do what you got to do. What's your argument as to why that doesn't justify this action?
Handcuffing Mr. Purrier was unlawful at that point because there's still no reasonable suspicion that he committed a crime or that he was armed and dangerous. If anything, the driver's conversation with the other trooper, the driver's taking ownership of that pill bottle, so there's nothing to indicate that Mr. Purrier.
Well, constructive possession is right there next to him. I'm not sure that argument helps you. Isn't your argument the fellow officer rule? Yes, the arresting officer can act on the information from the other officer. I have PC. You can do what you got to do, which would justify the handcuffs and the search. The problem here for the people, and I'm just using your argument, I'm not making things up here. In the motion papers, your client's lawyer challenged the reliability of the information from the sending officer. That puts the people on notice. They have to bring in the sending officer. They have to prove that he had PC, and they didn't do it. They didn't bring the sending officer.
Exactly.
They just brought the receiving officer. That's why the pill bottle doesn't justify probable cause.
Yes. So this was an unlawful search of the car. And even if there was probable cause to search the car, we still have this issue with the handcuffing of Mr. Purrier without reasonable suspicion.
Well, both officers saw the pill bottle, as I recall.
Yes.
The officer who put the cuffs on said, I saw the pill bottle.
Yes. So both of them see the pill bottle, but Trooper Manley testifies at the hearing that he knows just an unlabeled pill bottle is not enough. And even
Right. I don't want to put words in your mouth, but my understanding is that he couldn't, your argument is he couldn't independently establish either reasonable suspicion or probable cause, just based on the fact that I observed this unmarked pill bottle, unlabeled pill bottle.
yes. Yes, and it was even his subjective understanding that that wasn't enough for probable cause. That's why he goes over to the other trooper and he says, oh, there's this pill bottle. And the other trooper says there's probable cause to search. And Trooper Manley's testimony is, I don't know why he said that.
Right. Manley couldn't hear what was being said. There probably was probable cause. Okay. What probably happened was, because we know there were 74 Percocets in that unlabeled bottle. the driver said something to the other trooper that gave that trooper probable cause and all that. If we were going to wager on this in Vegas. The problem is the people we don't know that, the people needed to call that trooper because the defendant's motion papers had the magic words. We challenge the reliability of the sending officer's information. But for that in the papers, you lose.
I agree that they needed to have the sending officer testify at the hearing to establish probable cause. And they did not meet their burden here. And so all the fruits of his illegal seizure need to be suppressed.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. I want to, there's a lot of moving parts in this traffic stop, and I think that it's probably most productive if we clarify where the people's argument rises and falls. And I agree with Justice Presiding that I think the people's actions or the trooper's actions are justified if the fellow officer rule imputes the information from the trooper on the driver's side to the receiving officer who is on the passenger side, who then takes actions based on the probable cause to detain defendant.
I know you want to walk through this, but just to stop you for a moment, the people, you concede then the trooper Manley did not independently have reasonable suspicion of probable cause at the passenger door.
I would say he did not have probable cause.
He did not have probable cause. And
Trooper Manley independently, based on his own observations of the defendant's actions and what was in the car, did not have the required probable cause to detain defendant. That is correct.
Did he have reasonable suspicion?
I think that is a much closer argument. I think he would have been justified in asking defendant from the passenger side window what was in the container, and those sorts of questions on the divorce standard, I think would require reasonable suspicion. So I think that here, I think that's based on an officer's general day-to-day experience about, what types of things may be in pill bottles. I know this is an unmarked pill bottle, and I know that not anything, but anything small enough could technically fit in that pill bottle. I think that does meet reasonable suspicion, but I think that might technically be a little bit of a red herring here because everything was argued in the context of you can take Bill out of a car for.
Take him out of the car is fine. We're talking about the cuffing.
Right.
He testifies I cuffed him as soon as I asked him to get out of the car.
And the probable cause he got for the cuffing was based on the
fellow
trooper,
officer. Yeah.
the fellow officer rule.
Who didn't testify.
And my argument would be that these cases are concerned about what I think a couple times has been labeled a pyramid of hearsay. And what that is, in the reply brief, the counsel discusses this case, Havelka. And I think that's a good case to contrast with this set of facts, because in that case, I believe it was the owner of a bar called 911 to report possible violence. And there, the troopers, or I don't know if they're troopers, the police responded. And based on that tip alone, after it was passed through dispatch to a lieutenant to the actual arresting officer, all they knew was that, there's a potential, I think they said a possible gun battle. And the instructions to the arresting officer were get down there. And there was no observation from any of the officers involved in that common investigation that there was PC. And I think that's a big difference.
Let's say you're right on the fellow officer rule.
Okay.
Even though the defendant challenged the reliability and the people didn't bring in the officer who actually had probable cause. But let's say you're right that information relayed to the arresting officer suffices. Do we not have a concepcion problem here in that the trial court did not find probable cause or did not base the lawfulness of the police conduct on the fellow officer rule? The court said police can order somebody out of a vehicle without any particularized suspicion, citing Garcia, which is true. Then the court says the troopers lawfully stopped the vehicle and therefore authorized to direct the occupants to step out. The firearm was in plain view, tucked in the defendant's waistband. This observation provided probable cause. That was the basis, not the fellow officer rule. The problem with the defendant says with that is, yes, you can order somebody out, but you can't handcuff them. And the plain view observation took place after the police illegality, which was the immediate cuffing. That's their side of that.
I would argue that there isn't necessarily, yes, the order didn't decide every argument that was forwarded for a reason that the stop was illegal. However, probable cause, the fact that there was a finding of probable cause, or in my argument that there was probable cause, is necessarily inclusive of the arguments that were required to deny defendant's motion. And that's reasonable. Well, first, I know we're not really talking about this, but just to order people out of the car, that's the lowest level that you need. Really, there is almost no standard there.
No
The
problem.
lowest possible.
Could I interrupt here just for a moment? Because they may, the defendant makes a different argument in the brief regarding Garcia. You have to read Garcia along with Thomas. And you quote both Thomas and Garcia. In fact, you quoted Thomas first. Where Thomas, People v. Thomas talks about this idea that if you're going to be detaining someone for longer than what's reasonable under the circumstances, once you're going to do that, then you need reasonable suspicion of criminal activity, and that never happens. So there's this whole notion under Garcia, oh, gee, yeah, you can let them right out of the car. But if you don't do that immediately, you don't pull them over and say, okay, come on, let's everybody get out of the car. If you don't do that immediately, if you want to try to do that later, you've got a Thomas problem. So then Garcia really doesn't apply once you have.
It is, I agree, Judge. And I think that this was a situation where multiple different standards were being thrown at the trial court. And because this was kind of an evolving, like, I don't want to say the word evolving is not correct, but this was a very fluid traffic stop where there were two officers and they were kind of operating on two different pages until they would decide to make this, to get everybody out of the car. And I think that the evolving standard of a traffic stop is, yeah, when you make the initial stop, you can order people out of the car for, for safety reasons, for these different reasons. If you can, but that detention, let's say a traffic stop happens immediately. The troopers say, can you get out of the car so we can talk about this? Because maybe it's unsafe or whatever. That detention itself can't go beyond the time period of a normal traffic stop, like what the traffic stop would be if everybody was still in the car.
But that's not what happened here.
It's not what happened here. So what happened here is you need
why are we even talking about Garcia?
Right. I think you need, it's just the first in the line. So first you need, if you're going to do it, you have to do it really early. If you don't do it really early, you then have to have reasonable suspicion. And if you have probable cause, you necessarily have reasonable suspicion, and probable cause opens the door almost literally to having these other detentions. So I think my argument would be that the fellow officer rule allows Trooper Manley to conduct like an arrest here, a detention, and see the evidence in plain view because it is necessarily a higher standard than all those other things that are required. And for that reason, when the court in its brief, but I will say brief but encompassing decision says, yeah, that the stop was lawful and therefore, and also ordering them out of the car was lawful. I think it's lawful though for the officers to order people out of the car if there's probable cause. And
so the probable cause was the pill container. Right.
Well, no, the observations of a pill container would be less than probable cause.
Right.
Combined with the statement from the driver
to an officer who never testified, unknown statement.
No, I don't know if it's unknown because my argument here is that the information that was the basis of the probable cause was brought out at the hearing. Did
the arresting officer know any of that information when he put the handcuffs on?
No, he did not.
Right. He didn't know anything.
But I think that it's okay as long as the actual information is put in at the hearing, which was this bottle contained pills that they didn't have a prescription for.
Where do we get that information from? The arresting officer, right? Or no, I'm sorry, the sending officer.
They get from the driver.
Well, from the driver to the sending officer.
That's correct. To the receiving officer. So there's no links here.
So do you know what the driver said to the sending officer?
I don't know word for word.
Right, nobody does.
But did he say he had a prescription?
I don't know if I think he might have said, I don't know if he said he had, I don't recall. He said he had a prescription or not, but they knew that there were improperly marked pills because of the substance of the statement. And so I think based on the case law, that this isn't a situation where there's an officer who just says, hey, go arrest those guys. And that's the only evidence that's put in at the hearing. That's essentially what we have in Havelka. Here, the chain is put in at the hearing. The officer who had the information didn't have to testify because the receiving officer eventually learned what the substance was and testified to what it was at the hearing.
A little risky just calling the arresting officer when the one who has probable cause sits at home.
It's a bit of prosecutorial discretion that
when the defense alerts you in the motion papers, you see those words, we're challenging reliability, that should send off flares.
Yes, candidly, I don't know the reason why the sending officer wasn't called. This is a situation where if we look at these other cases from the Court of Appeals like Petralia, they do have legitimate concerns, legitimate reasons why a sending officer might not be called. Like, let's say it's an undercover officer, they don't want to expose it at the hearing level. That's not the case here, but it does provide a legal basis for what the people introduced in evidence.
Thank you, Mr. Ash.
Thank you.
Case number 511 is People versus Demetrius Gorey. Case 511. Good morning, Counselor.
Good morning, good afternoon. Thank you for your attention to this matter.
Sure.
This incident involves a 17-year-old person, Collie Quinn Sandwick, that occurred around May 23rd, 2023. The first issue I wanted to raise is that last night I reviewed my brief as well as a prosecution brief. And the prosecution concedes that count 1, rape 1, is a lesser included charge of count 3, predatory sexual assault. And the prosecution said it should be dismissed. So that's one thing.
You're off to a good start so far.
Yes, I was happy to, yes. The second is what I wanted to argue is that under focusing on counts, well, still that count 2, if you want to include count 1, what I spent time arguing in the brief and what the defendant himself had, there was a lot of communication regarding this, is that the verdict was against the weight of the evidence and unsupported by legally sufficient proof of forcible compulsion. What my client and I would like to point out is that when it comes to physical force, there's a lot of, and examining the victim's testimony, there's a lot of inconsistency regarding what force, if any, was used, and what resistance, if any, was used. If you just from the very beginning, the two men meet at a bus stop, and the victim goes to work. There's a lot of text communication. Bobby or Gorey says, and after work, because the victim works at a donut shop. Why don't you, bring over? I'll take donuts and you. It's very seductive. Come over. I'll give you a massage. It reads in a seductive manner to me. Once you're at the home of Mr. Gorey, then you have that's when all the inconsistencies start, from the time that they're in the living room until the time that the victim proceeds to the bath. In the first part of the testimony concerns with how much they drank, whether the victim drank more than Mr. Gorey. We would like to focus your eyes on the fact that this is a forcible compulsion case.
Now, with respect to that issue, I mean, really the only basis comes from the victim's testimony. And the victim testimony, that I agree with you, everything that you said up to this point, sort of the lead in and how this whole event proceeded from the meeting at the bus stop all the way through and text messages and everything. It's the fact that pushed me down on the bed, didn't let me up on the bed. I tried to twist away, push me down. Well, why isn't that enough if the jury believes it? The jury may not believe it based on everything else you said, but here it looks like they did.
I can see that point. What we're pointing out that there's a lot of inconsistencies, whether he was pushed on the bed. At some point, the victim says he can't quite remember. There's more than that too. Being led from the bathroom into the bedroom, he couldn't remember. At one point, the victim says he was wrapped in a towel or pulled in a towel or dragged from the bathroom to the living room, and then he backpedals. All the major points dealing with force and resistance is backpedaled. And this is at every major stage. It's at the CAC interview, because you are dealing with someone that's 17 years old. So is at the CAC interview, is at the grand jury, all these testimony, and with the interview for the police. There's a lot of inconsistencies. Mr. Gorey himself was intent on sending me his impressions of all inconsistencies. He's very focused on that as well. I would also like to point out, not only do you have those factual inconsistencies, but the medical proof is very equivocal. I think what's interesting, when I was reviewing my brief, what's interesting is that the lab reports themselves were never admitted. You do have the witness, the expert testimony, but the lab reports themselves were never admitted. There was a lot of testimony about the sperm. And once again, the DNA does not go to the issue. Whether DNA was present or not does not go to the issue of forcible compulsion, which you still have to.
It does show that there was some sexual activity between these two people, right?
Yes, it could have been consensual.
Couldn't that the jury also look at your client when he was interviewed by the police? His story evolved first.
That's true.
She never came in there. I guess we call her, he never came in the house and never did this, never did that. And then he just, she was in the house, and then all of a sudden now the semen's there. So we obviously had sex, but I didn't rape her. It was consensual. If it's consensual all along, you would have thought that would have been out of his mouth from the beginning.
Unless he thought a 17-year-old couldn't give consent. I don't know.
Yeah.
The doctor, Dr. Hall herself, said that there's no, there's no internal trauma, there was no bleeding. She said, the doctor said it was the trauma that she saw was consistent with consensual sex. We're just, just overall, we would just like the court to focus on the fact that the doctors themselves, and also the victim backpedals, according to, if you read the transcripts. I mean, at one point, Quinn's testimony was it was no big deal. And then she says, when she was interviewed by the police, she realizes, this was a violent crime. I don't want to minimize an incident like this to someone that's 17 years old. It's not my intent. I'm just saying, I'm just asking the court to focus. I think that's very obviously serious issues. But the issue, we're saying that the evidence is very equivocal. It could be consistent with consensual sex. Another issue that my client spent a lot of time talking about was the fact that he thought that his right to a fair trial on the Sixth Amendment was violated, focusing on the jurors issue.
Doesn't one of the jurors say that she had two daughters that were raped while they were in college? And when the court asked if anyone could be fair and impartial. She doesn't answer.
No, and no one questions that.
Right. But so is it preserved?
Well, we're asking under your interest of justice jurisdiction to consider that. That's why I couched it in that phrase. My client was very intense on getting that across. It was making sure I had the name right.
Right. It seems like more ineffective since a counsel claim in that.
I know, I didn't really.
Because I will grant you a witness or a prospective juror who had two daughters raped on a rape case. Most defense lawyers are going to challenge for cause, if not a peremptory.
Exactly.
This defense lawyer did neither.
Exactly. That's to me is inexplicable.
But that may be the subject of a 440. In effect, maybe the lawyer comes in and says, yeah, this wasn't, this was different. And there were other things she said earlier in voir dire that I really liked. Or she seemed to be nodding at everything I said.
Yeah.
You know, so there may be reasons we just don't know.
Yeah, well, I'm just speculating. Probably was lawyers up all night, prepping. He's going into court, he's tired. He misses something,
How do you miss that?
Huh?
How do you miss something like that?
That's what I'm saying. And that's my client really spent there's a lot of emails going back and forth, raising that as an issue. He wanted me to bring that up. So
no, we have looked at that carefully. There's other issues you've raised in your very thorough brief, and we're going to take a close look at all of them.
Thank you for saying this there. It's fine. Thank you very much.
Thank you. We will now call case 512, matter of Kelly M. Paulson versus Douglas P. Paulson Sr.
Good morning, Your Honors. May it please the court, Vera Vinkova for appellant Kelly Paulson. I would like to briefly summarize my argument and then address the issue of a subsequent court order, if that's okay with the court.
I have a feeling Justice Del Conte was going to ask you about that.
Yeah, why don't we change the order? Let's talk about the mootness potential.
They kind of go together. So the subsequent order, the original petition was a de novo petition. The subsequent order was a misguided attempt to make a bad situation better. And I say misguided because although the parties have agreed to arrangement that in theory would have given them 50-50 custody of the younger child, in reality, it didn't work that way because they live in separate school districts. And in effect, by consenting to this order, my client potentially waived her issues that she raised on appeal. And she had agreed to something that she thought would put her child in a better situation because he would spend half of his time with her. But in reality, actually resulted in this exact
Let me ask you
same.
a couple of questions so I can clarify this in my mind. Your client's really not making any contention with respect to the older child, her daughter.
So
she'll be 17 in a month.
correct.
And I think in your opening brief, you indicate that she doesn't want to live with your client.
That's correct, Your Honor. My client has a lot of concerns with respect to her older daughter. She does truly believe that it would be best for her.
The issue here is really the son.
Right.
And that issue with the son was addressed in the subsequent order. Now the parents under the subsequent order have shared primary physical custody.
So they attempted to address it. What they didn't take into consideration is that his special needs placement in the school that he's attending is already an extra expense for the school district, where they're busing him to the specialized school. And while in some instances, schools have made arrangements when you have a week on, week off schedules, in this case, they're not. So although there is a subsequent consent order, it in practice made absolutely no difference to my client. She's only seeing.
So you're saying there's only bus service every other week?
No, I'm saying that the child is attending the school from his father's house.
Right.
And is only visiting with his mother on the
Okay,
weekends.
so, but there is a subsequent order that gave her 50/50.
Correct.
But for this busing issue or school issue, this appeal from the prior order would be moot, right?
My client was seeking residential custody, not just 50-50 arrangement. And my client's overall argument was that in making its determination, the court seemed to emphasize her decision-making with respect to her significant other and judge her judgment in respect to that decision-making so much that
Represented by counsel when she entered into that consent agreement?
she was, Your Honor. And her trial counsel represented to her that it would not moot the appeal. That the issues that she appealed were not addressed in this order and that we could still proceed with the appeal.
Is there a motion to modify this more recent order because it's not working out as anticipated?
There is nothing pending before the court at this time. I discussed this with my client, and her position, legally speaking, is she doesn't believe that the first decision was correct, right? And on a de novo application, there are a lot more factors that the court would consider than on a modification petition, right? Because it's only about the change in circumstances. It's only about, an actual narrow set of facts. But the court never considered in its initial determination the father's ability to care for the child, his financial situation, his living arrangements. There was no testimony about it. And therefore, the court could not have considered it. So my client's sincere hope was that this court would send the case back down for the judge to consider all the breadth of factors that the case law supports in a de novo consideration, not by virtue of her going and filing another petition for modification. So unless the court has any other questions, I'll rest on my papers.
Thank you.
Morning, may it please the court. So our position is the appeal is moot.
You're the AFC?
I'm the AFC, yes, I'm sorry, I apologize. And for the mother to come in here and say, essentially, she wants her cake and to eat it too. I disagree with the first order, but I consented to a new one. But if you don't agree with my position, then I want to still have my day in court. It's a little troubling to me. I don't think it's a good use of judicial resources, but here we are. They agreed to an order subsequent to this matter or to this instant appeal. But even so, family court did make the right decision. The mother made a series of poor decisions. It wasn't just the new boyfriend that she met online and, had a secret affair with and moves in with him a few months later. It's the fact that she uprooted the child, moved him, I believe it's about an hour away. Some of the testimony says it's an hour. She doesn't have a car. She has no way to facilitate the parenting time. She didn't enroll him in school. Everybody knew that he had an IEP. He has very special needs. So to make these selfish choices to better her situation because she wanted to move in with this new person, the standard here is what's in the best interest of the children, not the mother. So
right now, we have the new 50/50 order.
Right.
But in reality, on the ground, the child's with the father a lot more than half the time.
Right, because, and I know this is outside the record, but in my investigation on this, it seems the school will not bus him from mom's residence because the child's being bused from dad's residence, and for one reason or
The
another.
mother has no transportation to drive the kid.
Correct.
That's usually how it works, right? You have bus for one parent, the other parent drives.
Right. And I would submit that the parties had counsel. They could have, there was no rush. Petition was filed in June. They do their order in November. Somebody could have investigated whether this was going to be a problem to continue the child in the school district doing a week on, week off, and what was the transportation situation.
Doesn't it make sense to then modify again and give the mother weekends, try to facilitate the child should be with the father school nights because of the busing, but maybe accommodate the mother in some other regard.
Right. Or implementing the order that the family court judge decided
that is before the court prior to the stipulated order.
Is your client fine with the arrangement now?
The younger child, he'd like to see his mother more, but I don't know that they really can because there's just these logistical problems between them. Had she not created a logistical problem that she could not solve, that I mean, she has to rely on transportation to.
So your client wants to see the mother more. She represents the mother. Sounds like you're arguing against the mother here. Like, isn't that against your client's?
No,
No.
because first, I think I have the ability to substitute judgment.
Sure.
And the trial AFC didn't file notice of appeal, but he has significant needs and he's not.
You substitute, that's fine.
Well, wanting more time, more than every other weekend with your mother, I don't think is arguing against the mother today and against his interest.
Well, can someone just re-petition the family court because it's changing circumstances?
Right.
With the busing?
Right. There are options available to this family. So we would just ask that either the court determine that the appeal is moot or affirm the lower court's decision.
Thank you.
Thank you.
Case number 513 is a matter of James K. Barrett versus Mertice G. Gaines. Counsel for the appellant is virtual this morning. Good morning, counselor. We have everyone else here. You may, we have Ms. Bates. Yes, we have all three. You may proceed.
Judge, are you talking to me? I'm an appellant.
Yes, yeah, you are the appellant, I believe.
I'm one of the appellants.
We have Ms. Jessie first on the list, and so you can proceed. Thank you.
Thank you, Judge. Family court's findings of fact and its orders lack a sound and substantial basis in the record. This is a 14-page decision that the lower court issued. It has several factual errors in it. The court very specifically linked those factual errors to its decision to deny the grandmother extraordinary circumstances. Because of those errors, I believe that this court should vacate the lower court's order and either remand the matter or use its own judgment to make an extraordinary circumstances finding for the grandmother. Specifically, the March 2024 CPS involvement, my client falling from the window, is what brought this matter most recently into family court. Absent from the record is any showing that the father, my client was 4 years old at that time. Absent from the record is any showing that the father had prior attempts to either get custody of the child, he hadn't filed anything in court, or to communicate with his service providers or his educational providers. My client is now 5 years old. He is diagnosed with autism spectrum disorder. He also has pica. I visited my client in the school setting to get the therapist's input on how he's functioning, and I am substituting judgment. Largely, my client, he does have language, but it's mostly echolalic. He'll repeat something that you say to him, but he does not engage in any sort of back and forth communication with anyone. He is in a 112-1 classroom. The court seemed to not only discount the findings of CPS in this March 2024 involvement, it was an indicated report against the mother, but the court went so far as to make some novel arguments. The grandmother testified to domestic violence between the parents. Even the father, when he testified, admitted that there was contact between him and the grandmother right on the eve of trial, that he had called the police because he wanted the mother to leave his home. In fact, the grandmother said he sent a video of the mother trying to kick his door in a police response. The court went so far as to say that it would not consider domestic violence in its consideration of extraordinary circumstances for the grandmother. That is, in fact, is an error. Additionally, the lawyers did not spend a lot of time talking about these CPS reports, yet the court spent a great deal of time in its reasonings as to how they were relying on the CPS reports. It erroneously.
Would you agree with the proposition that the fact that there's a report has been indicated against a parent or a grandparent or a party does not standing alone constitute extraordinary circumstances? There was no neglect proceeding filed, no abuse proceeding filed. It was just an indicated CPS report. That's not extraordinary. Would you agree with that?
I do agree with that, Judge. I do.
Would you also agree that for the grandmother to have standing, she needs to prove extraordinary circumstances against both the mother and the father?
Yes.
If it's just one, then she loses, right? She's got to have them both.
Correct.
Okay. You may proceed.
A complicating factor here is that mom was both an appellant and a respondent below. However, she didn't participate in the trial. On December 4th, when the trial started, she failed to show. I think this court should find her in default. The lower court could have done that. I don't know why the lower court didn't do that. Her attorney chose to sit mute. She attended all the proceedings. However, she made no arguments on behalf of the mother. This court has found in some of those circumstances that that is a parent going forward in a default posture.
What would you say are the extraordinary circumstances, the evidence of extraordinary circumstances against the father? Sounds like the father, correct me if I'm wrong, but maybe he's never lived alone with the children until now, but he's been involved. He hasn't, matter of fact, one of the other children, not even his, considered him a father figure. So he's been involved in these kids' lives since birth. He doesn't, so extraordinary so as to grant the grandmother standing here with respect to him, the father?
Specific to the father, it's incumbent on the court to evaluate the father's appropriateness. And I'm talking just about my client here, the youngest client, as a caregiver and somebody who can take care of this child. Dad very specifically said, not only has he never lived with my client, but he did not believe that his child has autism. Later, when he backpedaled a little bit, he said he simply didn't believe that he had to treat his son the way the professionals said he had to treat his son. He'd never been to the school, couldn't even identify the school. He didn't know any of the service providers, nor had he had any contact. It was, in fact, the grandmother who got all of these services for her grandchild. He was nonverbal. He wasn't toilet trained. It was grandma who reached out to the pre-K CPSE and got him services in a UPK program. And then
they may argue that this all goes to best interest. But when we say the father never lived with a child, he stayed with the mother and the children quite frequently. It's just that he never had the children in his own abode, separate and apart from the mother, right? But he did spend many of the nights with these children under the same roof.
He said he was there a lot, but now the lower court described Dad as defensive, and I don't remember the other word, but defensive and evasive. That's how the court described Dad. If you look at Dad's testimony, many of the issues the court tried to gather information about: how do you support yourself? Where do you live? Who else lives there? Do you have a criminal background? Have you worked? A lot of Dad's answers were, I don't know. I don't remember. It was unbelievable that he didn't have any information about himself. And it seems that the court should have had answers to those questions before granting him custody of his child.
All right. Well, thank you very much.
Thank you.
Good morning again, Your Honors. Vera Vinkova for respondent mother, Ms. Gaines. Your Honors, my client has the right and responsibility to raise her children in the absence of extraordinary circumstances.
Your client defaulted at the trial, never even showed up, right?
So the record is not very clear on what happened. There was on the day of the first day of trial, my client's counsel placed on the record that my client was not physically in the court building but was available by phone. There was nothing in the record that would indicate the court's response to that, whether it was unacceptable or what the other circumstances were. I don't know if there was an off-the-record conversation that resulted in the trial counsel not participating in the hearing. But the record before this court is absent. So in the absence of that record, I would ask the court to consider my client's brief and her position. And although it's clear that my client and her mother have some issues, the bottom line is that she appreciates that her children have a loving grandmother who is there to support when needed. And they will continue working through their relationship for the benefit of these children and for what is best for them, which could be a moving target. But none of the testimony that was presented by the grandmother establishes extraordinary circumstances with respect to my client. My client had lived with the grandmother at times. There was no testimony about grandmother personally witnessing any acts of domestic violence between the parents. There was no testimony about the children being present during any acts of domestic violence.
Well, there was the falling out of the window that seemed to precipitate your client voluntarily transferring that child to her mother.
So
kid fell out of the second story window.
There was a prior consent order where my client agreed that her youngest child should be in the grandmother's custody.
After the fall.
Prior to the fall.
Prior to the fall.
During the fall, my client had by default custody of the other two children, and the youngest child was visiting in her home. It was ruled an accident. The landlord did not install a screen. The child was out of sight, for a few moments. And what that precipitated was the grandmother's application for custody of all of the children because they were placed with her by CPS as a safety plan. But the CPS ruled it an accident and said the kids could go home. However, because of the court's involvement at that point, my client kept coming to court over and over saying, I am ready to take them. And the court did not, the court kept them placed with the grandmother because there was conflicting information provided by the grandmother and by the mother about what the CPS investigation status was. But the records clearly indicate that the children could have gone home within a couple of months. So unless the court has any questions, I'll rest on my.
Thank you.
Thank you.
Andrew DePasquale, AFC on behalf of the oldest child. And my client is the biological son of the mother, but has no relation to the father. So I'm happy to answer any questions about extraordinary circumstances, but I did want to provide the court with an update. My client is, it sounds like they're almost exercising visitation that is in excess of the current order.
With the grandmother?
With the grandmother. So it provides weekend access once a month. And it's sounding as if it's almost as agreed and arranged. So grandmother's position early on in this case was always that, we hope that these kids eventually go back to mom, but we just want her to get her act together, for lack of a better phrase. And from what I'm hearing from my client recently is that there must be some type of better relationship developing here, because it sounds like my client says, hey, I want to go over to grandma's, and there's no issues, and he's seeing her quite frequently.
Your client is fine with, your client wants us to affirm, let her mother, your client's mother and the grandmother work it out.
Correct.
And the father's not biologically involved, but hopefully there's some visitation there with the half siblings.
It sounds like there's not as much visitation going on with the father figure. He didn't provide much detail about that, but certainly it sounds like he's living with his other siblings, and he's seeing his grandmother quite frequently and on a flexible basis.
But you say no extraordinary circumstances we should affirm.
Correct.
Thank you.
Thank you.
Good morning, Your Honors. Allison Bates, attorney for the middle child, JREB.
In this matter, the family court properly determined that the grandmother failed to establish extraordinary circumstances sufficient to overcome a parent's superior rights, and therefore properly declined to engage in a best interest analysis. I want to address counsel's points that the family court was required to evaluate the father's appropriateness, or get answers from the father, that he was evasive. The family court was not required to do any of that because the family court was required first to reach a determination of extraordinary circumstances before engaging in that best interest analysis. Because no extraordinary circumstances existed, the family court was not required to do so. The issue in this case is not about whether the grandmother provided assistance to the parents or meaningful care of the children. She did both of those things. The issue is about whether the grandmother met the very high legal threshold required to displace parental rights. And I submit that she did not, that the record supports the determination and the order should be affirmed in all respects. Extraordinary circumstances can be approached both under the bright line rule under domestic relations law, section 72, or under the common law. Under domestic relations law, section 72, I don't think there's any dispute that the grandmother did not meet the 24-month requirement. Under the common law standards of parental unfitness, abandonment, persistent neglect, while there was certainly evidence of the grandmother's disagreement with some of the parenting choices, and there was speculation about things that were going on in either of the parents' households, there was no evidence before the court, no direct evidence of abandonment, persistent neglect, or parental unfitness.
Your client's with the father, right?
My client,
Yeah.
it lives primarily with his mother. Under matter of Michael B., I can report to the court that he does have frequent contact with grandma and father. As the other attorney for the child just mentioned, they do seem to have a good working relationship. My client sees all three of those family members on a regular basis. They actually all live within a pretty close proximity to my client's school. So I would ask the court to defer to the family court's credibility determinations, as this court often does in matters like these, and fully affirm the determination of family court.
Thank you.
Thank you.
Case number 514, Deborah Adams versus Michael K. Blodgett. Case 514. Good morning, good afternoon, good morning to you.
We're somewhere in between that morning and afternoon phase, so maybe brunch. But good morning, your honors, may it please the court. Adam Ferrandino on behalf of the Caesar Group, who are both an appellant and respondent with respect to this matter. I think the important thing to look at the outset is who is the client of the agency. The client of the agency is, for purposes of this policy, Silver Creek Optical. And it's undisputed that they're the named insured. It's undisputed that, we'll refer to her as Marcy Blodgett, is the person who handled all of the dealings with the insurance agency with regard to this policy. Michael Blodgett did not have any dealings with the agency with regard to this policy.
Policies that the optical LLC paid premiums for.
Correct.
Year after year after year.
Correct.
Protected the optical business from any claims regarding the building, regarding the parking lot, regarding the grounds as well, even though they were just a tenant and they arguably had no responsibility for those areas.
Correct. That was the purpose was to provide coverage for the business and the grounds with respect to this. It wasn't until afterwards that it was discovered that Michael Blodgett himself personally owned the premises. So
if the plaintiff in this personal injury case had brought an action against the optical business, the LLC, claiming as a defendant, claiming you're responsible for the parking lot, and let's assume the optical LLC admits that, says, yes, I am, even though they're really not, there would have been coverage for that.
that's true. That's true. And it's important, excuse me,
It's the same thing as if you have a situation where in a construction type situation. So I'm a subcontractor. I want a contract to do whatever at whatever construction site. And so I sign a contract, and the contract says that I have to get certain types of insurance, and I need to name the owner of the premises or the general contractor, whoever, an additional insured. And let's say the agency messes that up and they don't name so-and-so is the
We've seen that.
additional insured.
We've seen that.
Yeah, it happens. Unfortunately, it happens quite a bit. But the point is that additional insured doesn't have privity of contract with the agency to commence an action. What needs to happen is the actual person who is supposed to name it is the one who's supposed to bring the lawsuit, so that there is privity of contract with that. And it's the same thing here. And it's important to note that this happened this policy was in existence for years, and it was in existence for two separate carriers. Initially started with Hanover Insurance. Marcy Blodgett got the did the application, got the binder, approved it, received it, paid premiums for years, never asked any questions about anything.
Presumably read at least one of them, maybe, in your view?
You're presumed to read them, you're presumed to know them, and you're obligated to ask questions in the event that you have a question.
But we know that the Court of Appeals has said that that's not dispositive.
It's not dispositive, except for the fact that in this case, so that happens for the 2014-15 policy period, 2015-2016 policy period, 2017-2018 policy period. Then we have a situation where Hanover, because of certain circumstances, no longer is writing the policy, so it got placed to preferred. And remember, we have an insurance application from preferred, and you've all signed insurance applications. I've signed insurance applications, and you've seen probably hundreds of insurance applications and records on appeals before this court. What is the insurance application? The insurance application demonstrates to the carrier, these are the coverages that I want. These are the policy limits that I want. And if there's questions, these are the questions that I've answered. And right above the signature line at the bottom, it all says something to the effect of, I verify that the information contained on this document is true and accurate to the best of my knowledge, and I'm making these representations in order for an insurance company to issue an insurance policy.
But there's a broker in between. That's the difference here. I mean, the broker assists and guides clients through some of that process.
That's part of what's at issue here is the relationship between the broker and who may or may not be the client. I know you. Well, so with regard to this client, you're starting to touch on the special relationship. In this situation, it is admitted and it is unequivocal that there was no contract signed between the agency and the customer, this being Silver Creek. The only thing that was signed are insurance applications. That's not a contract between the agency and the customer. Number two, it's admitted that there were no monies paid to the insurance agency for its services. And number three, there aren't any of the remainder of the Murphy versus Kuhn prongs that a court would look at to determine whether or not there is a special relationship.
So let's answer this question just factually. Let's say Marcy, who doesn't own the land, Blodgett owns the land, but Marcy met with Mr. DePeters. Mr. DePeters is the insurance broker agent, if you will.
Right.
And they did meet, right? They're the two who had this discussion of what coverage is going to be.
Yes.
And Marcy says, my boyfriend, soon to be husband, owns the land. We own the business. Want to make sure that he's covered as a property owner. And DePeters hears that, but doesn't get that coverage. What plays out then? You would say, well, Mr. Blodgett doesn't have any privity there because he wasn't the one who made that request. Marcy would have to sue on his behalf.
So Silver Creek would have to sue the agency.
Because there is an issue of fact that went down the way I just said, right? Marcy says that she says that. And I know Mr. DePeters says no, but that would be.
But in the interim, I think I understand that there's this discussion and dispute with regard to discussion, but you can't do that in a vacuum when you have signed application for Hanover, you have signed application for preferred several years later. We can all discuss, you could go to your insurance agent and you could discuss all.
I'm not talking about discussing, I'm saying requested.
So
she requested something, and then I understand the policies don't say it, but is the burden on the policyholder to read through it? Like, did I get what I thought I asked for?
Yes,
there is
a
burden. And if
yeah,
even if you specifically requested, the broker just forgot.
There's an obligation for the customer of the agency, whoever that is, to look at it, to make sure that it is what they asked for. They sign documents that demonstrate that's what they asked for. They verified it, that's what they asked for.
So it's kind of like in McDonald's, you go through the drive-through, you gotta look in your bag before you pull off, make sure you got everything you order.
You get what you want. And who is in a better position?
Let me ask, following up on Justice Lindley's question here, but if that request was made from the fiance, soon to be spouse, that request is made, but the insurance is not procured, doesn't the broker then have an obligation to tell her, hey, we didn't get that for you? Or does she got to glean that herself by leafing through the insurance policy?
The obligation of the agent pursuant to common laws to either procure the insurance coverage requested or advise within a reason.
Alert that you don't have that.
Advise for whatever reason
coverage isn't there.
That you can't get it, but that doesn't change if, let's say, that all happened. For argument's sake, that doesn't change the fact that Michael Blodgett doesn't have privity to sue the agency.
Right. Your point is he's not the one who made the request.
Correct.
Somebody else made the request.
Well, did he comment in his deposition? They both commented, they both requested that they wanted the business and the property to be insured.
Well, that's what they said. We have said otherwise, but then it's
still a question of fact then, or?
I would say no, and the reason why I would say
you don't have the notes to support that at all, do you?
I don't, right, and that was a subject. That's a subject of a different motion that was decided.
But maybe those notes would have shown that a request was made.
Right, but even regardless of the notes, it goes back to
disappear. Does seem kind of suspicious.
It still goes back to the fact that she signed documents stating that what she wanted years later and accepted policies throughout that time without having any question about anything with regard to those policies.
All right. We understand the argument and we will read your brief very carefully again.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Christopher Bopst, and I represent Michael K. Blodgett in this matter. I want to just briefly respond with regard to the issue about the review of the policy. I don't know how often the Court of Appeals judges go to McDonald's and check their bags, but in the case of American Building Supply Corp. Versus Petrocelli Group, Inc., they specifically stated, while it is certainly better practice for an insured to read its policy, an insured should have the right to look to the expertise of its broker with respect to insurance matters. So again, there is no de facto, well, you didn't read it, so therefore you're out of luck. With regard to the privity argument, I would say that that there are two bases by which privity can be found, and one is actual privity, and two is near privity. And I'll start with the near privity because to me that's a more easy case for the court to decide. Courts have held that a near privity can create a liability against an agent when the relationship exists between an agent and a plaintiff that is so close to approach that of privity that it would not be unjust to extend such a duty to the agent. So, and that's been found when a party has relied on a broker to provide services for a lengthy period of time, and where defendants were on notice that the plaintiff was relying on the agent's expertise and ability. And those conditions exist here. And Mr. Ferrandino did not get into the full dynamics of the relationship between Mr. Blodgett and Caesar Group. And I think those are important. So I'll adumbrate them for the court's consideration. If I may.
Talk about the funeral businesses, they had a relationship.
Yes, that's correct, Your Honor. So was a long history of relationship between Mr. Blodgett and Caesar Group, dating back from 2010, when he first became a customer of the agency, when he used them to insure his first funeral home in Western New York. Mr. Blodgett then used Caesar Group to buy or to procure insurance on several other funeral homes. He used Caesar Group for all of his needs, his life insurance, his workers' comp. He relied entirely on Caesar Group for his insurance. And in fact, Mr. DePeters even served as a conduit for Mr. Blodgett's purchase of one of his funeral homes. So it's not a situation like in the concept that Mr. Ferrandino described, where you have perhaps an additional insured that wasn't added, who never communicated with the broker, never had any contact whatsoever. In this case, there was a long relationship between Mr. Blodgett and Caesar Group. And these transactions all followed a pattern. Mr. Blodgett would buy a business and a real estate parcel separately. He would then contact Caesar Group, Mr. DePeters, and Mr. DePeters would insure both of them. It followed a form. So in 2014, Mr. Blodgett buys in part with his wife, or to-be wife, this optical business, and he then also buys the real estate in his own right. Contacts DePeters. He says, do this the same way we did all the other ones. Okay, no problem. Again, that testimony is not refuted. Mr. Blodgett testified in his deposition that he contacted Mr. DePeters and told him, please get me comparable insurance to what I had for the other businesses. Mr. DePeters.
Didn't he basically do that almost by saying it as Justice Nowak indicated previously, that the optical business was insured and the property was insured as well, maybe wrongfully, because Marcy, the optical business, didn't own the property. So wasn't he acting on that? They're doing the same thing. I'm going to insure the business and the property.
Well, the testimony, though, also shows, Justice Montour, that he testified that he told Mr. DePeters that he personally owned the real estate. And Mrs. DePeters also, Mrs. Blodgett also testified that in her discussion with Mr. DePeters, of which there, as the court noted, there are no notes, that's already been the subject of a spoliation order, which this court's allowed to take judicial notice of. It was testified by Mrs. Blodgett that she told Mr. DePeters that, yes, Mr. Blodgett owns the real estate.
So Mr. DePeters doesn't get to make that error by saying, well, maybe I made the mistake of insuring the property and the business under the wrong parties. While Marcy and Mr. Blodgett can, according to American Business, the Court of Appeals decision, reading the entire insurance policy is not determined.
No, it's our position, Your Honor, that he was obligated to secure the coverage that was requested, and he did not do so. And in particular, I want to refer to a case. This is the Jaworski versus Select Quote Insurance case. This is a case that Caesar Group has said is the case that's directly on point. And in that case, it said in particular, a non-policyholder spouse having direct dealings with an agency could give rise to a near privity relationship. So you have in that situation an exact spouse situation that can be grounds for near privity. And so at an absolute minimum, and that coupled with the facts that of the history between the agency and Mr. Blodgett, there is near privity, or at least at a minimum, a fact issue of whether there's near privity.
In your view, these issues should be decided by the jury or the trier of fact, at the very least.
We would believe so, Your Honor. Yes, and
I think we
this And the same thing with the privity argument. The actual concept of privity as interpreted by this court is not as narrow and cribbed as my opponent would lead the court to believe. There's a case, Tchaikovsky versus Ernst & Young LLP. In that case, it held that a defendant's duty to act in a non-negligent manner towards a limited partner of a company for which the defendant was contractually obligated to perform actually states actual privity. And that supports a finding of actual privity. In this case, you have Mr. Blodgett as a co-owner of the business that was insured, the Silver Creek Optical, and he owns the real estate in his own name. So that case alone would permit a finding of actual privity, even though his name may not have been on the actual application. The fact that he was a known partner in a business that was insured would give him privity rights against the agency itself. With regard, and again, that's independent of whether a special relationship exists. That's just plain privity. Whether there's a special relationship which would impose additional duties beyond those normally imposed on an agent, which Justice Del Conte noted would include not just securing coverage if it's requested, but actually informing the insured or the client, I should say the better word, that, well, I didn't get the coverage or I can't get the coverage. If you have a special relationship, then that goes beyond those duties. So you have a duty to actually advise, well, okay, this is the coverage that's necessary. And again, in that case, the standard set out by Voss versus Netherlands Insurance is that it arises where there's a course of dealing over an extended period of time that would put an objectively reasonable insurance agent on notice that their advice was being sought and specially relied upon. And I'll emphasize those words again, objectively reasonable insurance agent, because that screams out fact issue for determination by the court.
I'll just ask you to be mindful of your time. You have a few minutes left.
Okay. And again, that special relationship is borne out by the relationship between the parties, the lengthy history, the fact that Mr. Blodgett had no experience or background in insurance. He didn't know what these terms meant. He was relying entirely upon Mr. DePeters and Caesar Group. And then when he called up and said, hey, I bought another business, take care of me like you did every other time. And that's what he was expecting, and he didn't get it. And it's our contention that that's a breach of his duty and that should be liable in negligence for that failure. Unless the court has any other questions, I'll rest on my brief.
Thank you.
Thank you.
Case number 515 is Denise S. Brennan versus Camden LLC. Case number 515. Mr. Kerwin, good morning to you.
Good morning, Your Honor, or good afternoon, Your Honor.
Yes.
Ready?
Please.
May it please the court. My name is Terry Kerwin, attorney for the appellant here. It appears that the lower court failed to recognize that there's a duty to maintain in addition to a duty to warn in situations like this where there's water left on the floor in a public facility such as McDonald's. The court determined that the defendants met the initial burden, which the burden would require them to establish that they did not create or permit the wet floor, which they've admitted to in affirmations. So how
in this case, my view of the record was that you had only brought one cause of action. Plaintiff only brought one cause of action for negligence. The failure to warn is within that, it's even in the complaint, not even like a bill of particulars, but then also leaving the floor in a dangerous condition is in that as well, separate, but all under one cause of action. Is that right?
I think that's correct, Your Honor.
Okay. Do you know whether plaintiff could have separated those out into two separate causes of action, a failure to warn and a negligence in terms of the way they left the condition of the floor?
I think they both fall under the heading of negligence.
Fair enough. Okay.
You don't dispute that the defendant met their burden of proof on the duty to warn claim, failure to warn claim. They had that yellow caution. It was right there for everyone to see. You don't dispute that that claim should be dismissed. You want the failure to maintain the property in a reasonable, safe condition. That's a separate and distinct claim than failure to warn. You're here on the duty to maintain, correct?
Correct.
So you wouldn't have any objection if we modified the order by dismissing the claim, not the cause of action, but the claim for failure to warn.
Yes, in fact, Denise Brennan indicated in her testimony that she clearly saw a warning sign, yellow warning sign.
These wet floors cases, we see a number of them, where the floor is temporarily wet due to mopping. There's case law from the first and second department. We haven't explicitly adopted it at this point. That says a floor is not inherently dangerous if it's wet from being washed. The plaintiff has to show negligent mopping, excess water, like in the case Denard that was signed. It was a puddle of water. It has to be some abnormally slippery cleaning substance. You don't take issue with that principle, right?
I don't take issue with it, but it was clear that it was slippery. She fell,
Right.
her grandson fell, and she fell.
In her testimony, the plaintiff's testimony submitted by the defendant in support of the defendant's motion, your client said the floor was very wet, extremely slippery. In your view, that raises an issue of fact, even under a negligent mopping theory, therefore defeating their motion. They can't meet their initial burden if evidence they submit raises an issue of fact.
Absolutely.
What do you make of the Rivero case? The trial court, the motion court found Rivero versus Spillane Enterprise is a case from the second department, 2012, to be on all fours. And it does appear to be on all fours. It was a McDonald's. It was a slip and fall after somebody mopped. The trial court said, I'm relying on that case. It dictates granting defendant's motion. What's your response to that? Why shouldn't we follow that and rule against you? That case.
Well, I think my response to that would be the last paragraph on page 7 of the record in the order, where Judge Antonacci indicated, even assuming that defendants failed to establish as a matter of law that condition was not a dangerous one, defendants met their initial burden of showing their entitlement to judgment by demonstrating they placed wet floor signs. So
right. That's what Rivero says. Rivero says McDonald's had a warning sign for the wet floor. Therefore, that defeats the failure to maintain dangerous condition cause claim.
Well,
that's what they said there.
But then I would rely on Cohen, which says that whether defendants were negligent in creating or permitting the condition that led to plaintiff's injury, not just whether they were negligent in failing to warn. So to me, it's two independent obligations on behalf of the defendant. You've got to warn. I mean, you can warn in a zoo that there's a tiger loose, and I'm sure you've heard a million analogies, but there's a tiger loose and may bite. And then when you go up and the tiger's running around, yeah, they warned, but they warned of what? Something that's a dangerous condition. And in Cohen, that's what they talk about. And they talk about the two duties being independent and analytically distinct of each other.
It sounds like what you're saying, and if it's what you're saying, I agree with you. Rivero is just plain wrongly decided.
I didn't want to say that, Your Honor, but I agree 100%. Unless there's any questions, I'll rest on the paper submitted.
Thank you.
Thank you.
Good morning, Your Honors. James, special for defendants here. So I guess I will start, as Justice Lindley pointed out, right. You're right that just having a wet floor isn't inherently dangerous, right? And I think what my opponents seem to say, which sounds strange to me, is, well, it must have been too wet because they slipped. But of course, we also have the video of plaintiff, multiple other people walking over the same area. Fine, one child is skipping.
It's a very good point that you make now and in your brief, and I looked at that carefully. I'm not saying it's a good argument at trial for the plaintiff, but the problem with the video that I saw was that the exact place on the floor at McDonald's where the plaintiff slipped and her grandson you can't see it. You see the floor beyond, and as the employee who did the mopping had claimed, he did sections. What was the condition of the floor exactly where she slipped? We can't tell from the video. It might have been a pool there, like in the case that the plaintiff relies upon. Might have been a big puddle. Might have been too much water. It would have been, the plaintiff never said, well, and when I got up, I was all wet. That would have been interesting. That would have been good testimony for the plaintiff, but the video doesn't conclusively, where you see all these people walking, that wasn't exactly where the plaintiff fell. So that, I think, would be the plaintiff's response to your, look, the video shows it wasn't too wet. What would you say to that?
Okay, so, well, then I would go back as you just said, we have the affirmation from Mr. Jones. He specifically says he carefully washes and then dries it with a mop as he's going through each section.
But we know it wasn't bone dry because you can tell she looked like she stepped onto the arena of the Buffalo Sabres and just went flying. So we know it couldn't have been dry, right? So it was wet. There's just how wet? Was it excessively wet?
Well, Judge, first, I don't know, too soon on the Sabres.
Yeah,
right there.
Yeah,
let's not talk.
Sore subject.
Talk about that yet.
Let me ask you about a different subject, if I could, then, besides the same. Would you agree or disagree with this proposition of law? A property owner who warns of a dangerous condition, signs everywhere, that does not defeat a claim that there's an unsafe condition, that the property owner failed to maintain the property in a reasonable, safe condition. Would you agree or disagree with that proposition? Warning alone, fulfilling the duty to warn doesn't necessarily fulfill your duty to maintain the property safely.
Well, I would say I would agree that it wouldn't necessarily do that.
You don't agree with Rivero, which is what the trial court relied on.
Right.
That's there.
Okay, so I wouldn't agree with that in every single case. I would say, and where I think the trial court was going with it in this one, she's claiming she slipped on a wet floor. There's a huge wet floor sign right next to her. I mean, it makes me think of an open and obvious condition that, right? I mean,
Exactly it. Open and obvious does not defeat, if a dangerous condition is open and obvious, case law is very clear, that does not defeat a claim of failure to maintain property in a reasonable, safe condition. I would maintain that the same goes true for having a warning sign. Open and obvious goes to the duty to warn.
Right.
So those are in the same bucket. If it's open and obvious, or in the alternative, there's a warning sign, okay, that's great for the duty to warn claim, but you still got the failure to maintain claim. I think that's the mistake that the second department made in Rivero, and again, the trial court relied on Rivero and another case that made the same mistake, I think.
Yeah, fair. I mean, I think here, I mean, ultimately, I would just point back to the affirmation. Actually, I should also mention, because Mr. Jones also said that no one else has fallen that whole day after he dried it. So I think there's an issue there too. What we know is that he said that he washed each part of the floor in sections, dried it. No one has an issue.
Your argument is better than the rationale from the trial court, which is based on the warning sign. Your argument is that it wasn't excessively wet.
Right.
Being normally wet is not dangerous.
Right, exactly.
And I think it's a really close call. It would help if we had the video of the actual part of the floor where she fell, though. Maybe it should go to a jury.
Oh, you don't need a jury for this one.
We do a bench trial. No, we understand your point. It is a close issue.
Okay, thanks. Well, if there are no more questions, I would rest on that.
Thank you.
Thank you.
Case number 516, George Bushley versus New York State Thruway Authority. Case 516. Oh, yes, I'm sorry. Thank you. Yes, Justice Ogden has recused on this case.
Yes, thank you.
Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the court. My name's Richard Abbott. I represent the appellant, George Bushley. This case involves an accident back in February of 2021 involving a New York State thruway snowplow operated by a gentleman named Peters. His route that day was the I-190 going southbound.
Right. He does all the exits. He gets off, goes on city streets to get back on the thruway. The accident happened when his plow was up on the city roads. It goes to trial. We have the two issues. Was the snowplow driver actively working on a highway at the time? And if not, was the driver reckless? Right? Those are the issues.
Yes, sir.
Okay. Which one do you want to tackle first?
I would like to address the actually engaged in work on a highway issue,
So
which
on
I
that
think.
issue, on that issue, you rely a lot on Hoffman, our case from 2009, and then we have Plummer in 2023. And it seems like they could be read together, but you argue that this is more like Hoffman, where you had this mile and a half, this intervening mile and a half, the snowplow driver had to plow an area and then went a mile away and then plowed another area. During that interim, we said, oh, then the statute doesn't apply. Regular negligence standard applies for that stretch. And you claim that this is more like that. But then we have Plummer, where if it's all part of the same route and there's parts that they don't have to plow, where they pick the thing up, but they're right on, it's all within one route, then the standard does apply. The standard would apply. Tell me, why isn't this more like Plummer?
Well, the factual situation in Hoffman is identical to this case. In Hoffman, he was a town employee, got off his route, goes on to a county road, which he had no obligation to plow, salt, patrol, do anything. And that's where the accident occurred. And the Fourth Department, this court, addressed the inclusion of the language actually engaged in work on a highway, and that to rule otherwise would make superfluous the phrase actually engaged. It was the activity at the time. And at that time, Hoffman wasn't doing anything. He was a motorist, just like Peters was a motorist on this day. And the only distinction, and it's a distinction without a difference, is that Peters was on a city road and Hoffman was on a county road.
We also have a distinction, though, in terms of the distance, and maybe that's without a difference also. I mean, here it's short. You're just getting off one exit, then you've got to go plow the next exit. So because you have to do the on ramps and off ramps, you have to get off here. But you may say, well, it's the same as in Hoffman, just because the two areas you had to plow were some distance away, you still had to get from one to the other. So I understand that. It's a little bit closer, it seems, here than that. Does that matter? The fact that it's he's only off the exits for a couple of minutes or for a shorter distance?
I don't think the time matters. It's the activity that matters. And if you're not working on the highway where your attention is diverted to your work, okay, you're held to a lesser standard of care, which
So
makes sense.
If he wasn't salting, which he wasn't, if he wasn't plowing snow, which he wasn't, then the privilege doesn't apply, in your view. You have to actually be plowing snow or salting, right?
Or patrolling, anything that
Looking for-
requires the operator's diversion away from the ordinary rules of the road.
Right, Hoffman talks
Which
about,
makes sense, and that's what the legislature intended. And the best indication of what a legislature intends is the actual words of the statute. As this court said, it would be superfluous if you eliminated the word actually.
so we got it
And-
wrong,
and
we got a number of cases wrong then. I'm not suggesting we're always right by any stretch, but Plummer and some of these others, we didn't apply the privilege to snowplow drivers who were on their route from one site to another. You're suggesting we got those wrong. We should re-examine those cases? In other words, Hoffman, you rely on Hoffman. We said the driver was not driving on the part of his snowplow route, but instead was traveling from one part of his route to another by way of a county road. I think the way the state may look at it is that our driver was on his route. He can't get to where he's going. This is his route that he always takes. He gets on I-90, gets off the exit, takes the city road, comes back, hops on the thruway. That's his route, even if he's not plowing. I think that's the way they look at it.
Oh,
But
that's not,
I'm
I'm sorry.
give you this, if we just look at actively involved, strictly, you are right. Because he was not actively involved in plowing or salting at that minute, at that moment.
Nor did he have an obligation to. The Attorney General concedes at page 18 of their brief, there is no dispute that Peters was not assigned to salt or plow Louisiana Street and was not engaged in either activity on Louisiana Street at the time of the accident. So he has to operate his snowplow just like every other motorist, because his attention is not diverted to his work, and he should be held to the negligence standard. And that's been confirmed. Hoffman has been cited with approval so many times on this very issue, including Orlano, which is a Court of Appeals case decided 5 months before this decision. And in that case, the supervisor was checking out the grounds to see, because there had been snowfall, that whether he was going to have his crew go out there. And he checked on it, was returning back to his office, and his attention was diverted to snow on his left when the accident occurred. And the Court of Appeals in Orlano said he wasn't actually engaged in work on that time, citing Hoffman.
If we disagree with you on the actively engaged in working on a highway issue, if we don't agree with you there, do you lose?
I don't think so, Your
Why
Honor. Reckless, I think this gentleman's conduct, there were so many violations of the vehicle and traffic law that I think his conduct would rise to the level of reckless.
You want to stack these, all of his poor behavior, his poor driving. If you stack it all together, you get to reckless. That's your position.
I believe so. I don't think the court needs to reach that because of Hoffman and the cases subsequent. But for example, did you look at your mirrors? I don't know. How many mirrors did you have? 5. You were on the same road as my client for 400 yards. He was driving a red car. Did you see him? I didn't know I even heard anyone. Okay. And did you look at your mirrors? No.
Can I ask you a question?
I'm sorry.
Because we're familiar with all the facts. He may have gone right on red, but did your claim, which is the complaint in the Court of Claims, did your claim allege recklessness by the driver? I will tell you it didn't. It alleged negligence.
Yeah.
You're in the demand for the bill of particulars. They asked, how was he negligent? Your response, he was negligent for failing, the driver was negligent for failing to see what was there to be seen. That's negligence.
Yes.
This is a low impact collision. The snowplow driver stopped. He said he was in my blind spot, he didn't see him. Sounds like your ordinary negligence case. Right? Like recklessness, the standard for recklessness here is the same as for reckless driving in criminal law.
Yes.
Do you think this driver, if he got charged with a crime for reckless driving, it would just never happen? And if it did, it would be thrown out of city court so quickly. It just seems like on the surface, yeah, he made some mistakes, the driver. But reckless is, we've had cases reckless, police officer driving wrong way, 100 miles an hour down a one-way street, wrong way. That's reckless. There was a case we had from the Court of Appeals that was decided last term by the Albany, came from us. Police officer goes through this, a red light without sirens activated against the right of way, collides with another car, not reckless, Court of Appeals said. Our driver here stopped at a red light and then proceeded, and then the front of his right front of the plow hit the front part, left part of the car. Well, it seems like negligence to me, but you see it as reckless.
Well, he saw and was aware of a no turn on red. He turned on red,
Yeah.
as confirmed.
That's some evidence of negligence. If you violate some evidence of negligence, I'll give you that.
But his activity became that much more dangerous due to the location of his snowplow. He didn't bother to look in his mirror to see if anyone was to his right, including
Counselor, if I may, my understanding is your argument is it's reckless because he didn't understand what was happening around him. It's the disregard of the circumstances. He apparently was unaware that he was on a 2-lane road.
we claim it's everyone, by all indications, by the width of it.
You had an expert.
Two lanes.
It's a 2-lane road, and he doesn't realize that there's going to be someone on his right. He's oblivious to that. That bleeds into the recklessness. This isn't just a normal right on red against the traffic signal. He's unaware and doesn't even look to see if there's a car to his right.
Yes.
Right.
And he's driving a very heavy vehicle. If they were positioned a few feet front or back, my client could have been
Right,
killed.
you're not making a speed case here. He wasn't the silver bullet racing through a red light. This was a large vehicle who was oblivious to the conditions around him. That's your argument as to why it's reckless.
Yes.
Right,
Yes.
but to be reckless, you have to knowingly disregard a known risk. How can you knowingly disregard? He didn't see him. He was in the blind spot. He just didn't see him. He didn't, as you said in the bill of particulars, he was negligent because he didn't see what was there to be seen. That's not recklessness. Is you know there's a risk and you're just going to disregard it. You're indifferent. That's a different standard. But we understand your argument. It's a close issue. And is there any final words you want to say?
If I could have 1 second, please. Peters testified that his route was the I-190 and the on and off ramps. He was merely traveling one route to another route that did not constitute part of his run or beat. And that's what this court addressed in Plummer. I think that distinguishes Plummer from or supports Hoffman. That it's not his route. He used it to get from route A to route B. And he's got to drive like every other motorist because his attention is not diverted to his work. I believe it's that simple.
Right, you're relying on Hoffman and it is a good case for you, no doubt about it. Hoffman's a good case for you to cite. We thank you for your argument.
Thank you, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors. Kevin Hill on behalf of the state. I will start with the first question of whether Mr. Peters was actually engaged in work on a highway.
About Hoffman, how would you explain away Hoffman?
Exactly, Your Honor. And I would like to say, just as a general matter, I think the case law is pretty clear as to two divergent outcomes. So on one hand, you have Hoffman, which makes clear that if an individual is driving between routes or between work sites, there's no privilege. Then on the other, which Hoffman implicitly recognized, is that when an individual is driving on their route, run or beat, whichever word you'd like to use, even if the snowplow is up or they're not salting, the privilege could apply.
What if their run includes roads that they are not assigned to plow or salt, like here?
Your Honor, that is certainly what Mr. Peters' testimony established, and I would respectfully suggest that is what distinguishes Hoffman. So first of all, the facts in Hoffman were not quite clear. I was unable to divine exactly what the basis for claiming the privilege was, but it does seem like he was assigned to plow certain roads, but then in order to access between them, he then went on a road he was not responsible for plowing. But what's missing from the record is whether he was required to use those county roads.
How else is he gonna get from A to B other than using it? He's gotta it's not like he can back up and go to another exit.
Exactly.
He's doing the exits.
Exactly, Your Honor. It is, for Mr. Peters at least, it was physically impossible for him to get between any one of his assigned exits directly. And so he had to use those city streets.
But not this one, not this intersection. So you get off at Louisiana Street. When you get off, he's got to plow that whole exit. It's a big curve around. And so you're on the 190, you're coming off at Louisiana Street. When you get to Louisiana Street, you probably had to plow both going straight ahead for folks that want to turn left on Louisiana and folks that want to go right. And it diverges there. It's like, so he had to plow both at some point. Certainly, if he's plowing the part where you have to go left, he's not crossing the Louisiana Street Bridge. That's only to the right. When he's crossing Louisiana Street, when he does this part right here and he finishes even the part to the right, he's now on a 4-lane bridge, and the accident happens at the other end of the bridge, over the 190. He doesn't need to take that. There's enough room for him to actually do a U-turn and go a different way if he wanted to, similar to Hoffman, right?
I agree with you. It is similar in that respect. But what Mr. Peters testified is that when he takes that exit 5 to get onto Louisiana Street, he always follows the same path. He takes Louisiana Street, makes a right onto Seneca, makes a right onto Hamburg to get to exit 4. And so,
but that's his preference, right?
That is
mandated. That's not required of him, is it?
That's correct, Your Honor. It's not required, but I would respectfully suggest that the repetition and regularity of it is what establishes a route. And if I could harken back to one of your questions from earlier, I tried tracing the case law for what is a route, could not find any, but I would respectfully suggest that there are certain characteristics this court consider. One of them you mentioned, the distance. Arguably, the farther away between sites, the less likely it is actually a route. But I would also suggest regularity, repetition is something to be considered. And finally, what is the relationship to the duty being performed?
Regularity. How long had he been doing this? I thought he was only working a couple of months here. And then he got fired because of this accident. I thought that's what the testimony was.
Your Honor, I'm unaware as to whether he was fired. I believe he may have been disciplined by his superiors, but I believe he was on the job for at least a year, but I might be misremembering. I apologize, Your Honor.
But the word route is we use the word route in these cases.
That's right, Your Honor.
I think we just use the ordinary plain word. Like, let's say I'm delivering newspapers and I have my newspaper route. And I have Main Street over here. I have East Avenue. Those are my routes. And then I take a side street. I walk down a side street. I'm not delivering. And then I get back on the Main Street. If anyone says, is that side street on my route? The answer would be no. My route is East Avenue and Main Street. So that seems to be similar. He's using these non-state roads to get to his route. Isn't that true?
So It is true that he was only assigned to 6 particular exits. He was not assigned to plow any of these city streets he was utilizing, although I believe he testified he would occasionally do so, but that's irrelevant for purposes of this appeal. But what I think distinguishes this from your hypothetical, Your Honor, is he testified that he always uses the exact same city streets in a particular order. And so that's what gets us into the colloquial understanding of what a route is.
Okay.
And so, I would respectfully suggest that the lower court's finding in that respect was a fair interpretation of the evidence.
If he wasn't actively involved, you would dispute negligence here, right?
Yes, Your Honor. To be clear, the lower court did not address negligence or contributory negligence, although we argued both in our post-trial papers.
But there's clearly negligence, right? I mean, we can make that finding.
Your Honor, I think you could make that finding, although I would respectfully suggest that you not, for the reasons we stated in our brief. Happy to go through the reasons.
So he knows it's 2 lanes as he's going over that Louisiana Street Bridge, which he elected to do. He knows that and when you get to the end of that bridge, he knows there's a T intersection. There's that street off to the right, but that doesn't go straight through. So there's these 2 lanes. And
Your Honor,
hang on, let me just go through.
I'm sorry.
Because I think that Justice Del Conte asked about this stacking thing. It looks like he's, to some degree, at least in the left lane, gets to the light. It's unclear from the testimony whether his turn signal was on until he was actually at the light. So he said, I think he said in it briefly, like as he was approaching, but then you read the testimony and says, no, it's when I was there, I thought I had it on. Plaintiff says didn't have the light on, but whatever. At some point while he's sitting at the light, decides, oh, I got to turn right. But he's in the left lane and there's no red on red and it's red. But he decides to then go ahead and do the turn, both from the left lane and without the red on red. And then just to throw in a little bit from Mr. Abbott's presentation, without checking any mirrors either, these 5 mirrors. Why can't that be stacked and reach a level of recklessness?
Your Honor, it cannot be stacked in that way because that would be resolving a disputed issue of fact that came up at trial, which was the northbound lane 1 lane or 2?
He testified categorically. He thought it was a 1.
Exactly.
There's
and it's
lines that indicate 2. Is it wide enough to accommodate 2? But he said repeatedly, time after time, he thought it was a 1 lane road. But I'm not so sure that it doesn't mean you can't stack. Like we stack all the time in these police car cases or ambulance cases. You didn't put on your siren, you didn't stop, it's never one thing. So I agree with the concept of stacking. And so if we stack them up here, the question is, does it get to that high reckless standard? And that's the question. Maybe went right on red. It was a little unclear. He stopped. What else do we have? Did he signal 100 feet? He said he didn't know. Like, who would know? Like, nobody knows when they signal, but he signaled. So he comes to a stop, he signals. He goes right on red, which, by the way, he doesn't have to follow the rules of the road. So that's not a traffic violation for him. He can do a right on red. It's not illegal. But all those things there, he did make more than one mistake. So do we put it all together? Why is that not reckless?
Your Honor, it's not reckless because the reckless standard is akin to one of subjective knowledge. And so even if this court were to stack the different errors, none of them would establish that Mr. Peters was actually aware that claimant's vehicle was beside him. And based on Mr. Peters' testimony that he believed the northbound lane was only a single lane, he wouldn't have any reason to think that there was someone behind him, to his right.
Do you think did you try this case?
I did not, Your Honor.
It appeared to me the whole trial, there was never a claim of recklessness alleged. The claim was negligence, the bill of particulars, negligence. It didn't even look like on the record, there were no opening statements, no closing, no written submissions at the end. So you don't know what people argued. But it looked like the entire trial was actively involved in highway. They'd never alleged recklessness to begin with. And now they lose, and now they raise it because the court did address it right at the end. Because but the main part of the judge's decision was he was actively involved in working on the highway. I'm dismissing it because there's no recklessness. It seems like it's being raised for the plaintiff for the first time in appeal. I'm sorry, for the claimant.
Your Honor, so I was only able to review the state's trial brief in which we argued all of the issues. It seems to me that claimant's argument about recklessness is fairly included, just in the nature of the claim itself, because it is our burden of showing that, because having raised the qualified immunity, it was our burden of showing that his conduct did not rise to the level of recklessness. But if this court wants to hold that,
Well, the claim itself alleges negligence.
that is
You're
correct.
saying that
That's our
maybe
record.
it got transmuted into a reckless allegation at some point?
I do not. I understood claimant to be arguing that the qualified privilege does not apply, and therefore he wins based on negligence.
Thank you.
Yes, thank you, Your Honor.
517, matter of Sean Mahoney versus John C. Garcia, 517. Counsel for appellant is remote. You may proceed. Good afternoon.
Good afternoon. May it please the court, Aaron Molisani on behalf of appellants. As you know from this brief record, this case is relatively straightforward, but without much case law to assist the court in its decision. Sean Mahoney used a gun to kill somebody. He is now seeking to have the gun returned to him, and the lower court granted his application to have the weapon returned. Our position is that primarily the gun is a nuisance weapon under CPL 400.05, which provides that a weapon that is used in the commission of an offense is a nuisance.
Your theory, if we buy it, which I give you credit for being forthright in your brief, you say this gun will never be returned to the gun owner ever because there's no statute of limitations on murder.
Correct.
So
Yeah.
the county, the gun owner can never be charged. If the gun owner is never charged, like 50 years from now, rolling in a wheelchair, I want my gun back. Nope, the statute of limitations hasn't run, so you can't get it back. It's a nuisance forever, right? That's your theory.
That's my theory, correct. By the plain language of CPL, an offense is just the conduct. So there's no reference in the statute to charges or an arrest. And that was the point that I was trying to make to the lower court with the addition of that transcript for the return of firearms, where it was another person who allegedly possessed a weapon without a pistol permit. And the court there said, yes, that's a nuisance weapon. And again, no arrest, no charges.
But counsel, if an offense was committed to be a nuisance weapon, but nothing's been established here in terms of whether offense has been committed, and if the shooting was justified, then we don't have an offense, correct?
Potentially. I mean, I think that the distinction I'd like to make is that just by the plain allegations that are made in the petition, he firmly admits he used the gun to shoot and kill somebody. And as far as
that's true. Nobody disputes that he killed someone, but whether or not that killing was justified or not, his position is it was, and it hasn't been presented to a grand jury. There's been no finding that it wasn't justified. So
exactly, but I mean, the circumstances that led to the killing aren't in the record at all. So in my opponent's brief, he talks about this being an absolute defense to criminal conduct, and I agree it is to criminal conduct, but I don't think that that means that an offense was not committed. And again, there's no record evidence of what led to the shooting.
So has the DA given a letter saying that the investigation is closed?
No, that's another point I wanted to make, Your Honor. My opponent in his brief said that all investigations have ended, and that's simply not true. The DA's office letter that the petitioner submitted specifically says that the investigation remains open unless and until the charges become legally sustainable. And the point on that I want to make, the petitioner argued that essentially all evidence that could ever exist exists now, and there isn't any charges that have been brought, which is only partially true. Charges have not been brought, but there is a pending civil lawsuit of the victim's parents or mother for wrongful death against Mr. Mahoney. And my point there is that I assume are going to have to testify in a deposition. And so that testimony may be useful in a potential criminal charge.
Yeah, I get, well, this case has been investigated for years now and no charges. But I get why the county may want to hold the gun, see what happens at the civil trial. Maybe somebody incriminates themselves. Maybe there's some evidence. But so I see that, but I don't understand why the county just can't make a video of the gun, take as many pictures as you want, test fire it, do everything you got to do. It doesn't seem like we already know what happened. We know the person shot the person with a gun. Like, that's not going to be a mystery. You don't have to really, why do you need to hold the gun to use the possession of the gun as evidence at a potential homicide case down the road?
I think the distinction there, Your Honor, is that on one hand, I am saying that the gun is evidence and that it's not eligible to be returned. But then separately, I'm also saying that under CPL 400.05, it's a nuisance weapon and is ineligible to be returned. And I understand sorry.
Under that section, under 400.05, when you get to that subsection 6, the legislature included a period of 1 year. They could have included the period, they could have said, well, it's based on the statute of limitations of the potential offense. They could have said it's until you get a letter from the DA's office. They could have said a whole bunch of different things, but they didn't. They said 1 year. And it seems to me that we have to read some import in that, right?
I read that as the 1 year being not in a situation where it was used in the commission of an offense. In other words, if it was seized, for a domestic violence call that the gun wasn't used specifically in anything, the gun can be held for a period of 1 year. And after that point, it would be considered a nuisance. Essentially, it's still hanging around the police station. So I think the distinction is between a weapon that's surrendered or confiscated as just a general safekeeping versus one that's used in the commission of an offense.
But counsel, doesn't 400.05 only determine whether or not the weapon can be returned? It doesn't govern whether the police, it doesn't cover when the police can destroy it. It just covers when the police can destroy the weapon. It doesn't address at all when the weapon can be returned, does it?
It does the section that Justice Nowak referenced as far as the 1 year. But my position is that the statute is straightforward and it says it will be considered a nuisance if it's used in the commission of an offense.
Only if the shooting has not been determined justified. If the district attorney has concluded that the shooting was justified, I could not see why this would be a nuisance weapon. And have they done that? Go ahead.
No, Your Honor. There has been, as per the petitioner's initial petition to the court, the DA's office file remains open. They have not made a decision about whether it's justified. That has, to my knowledge, not been submitted to the grand jury. And we just had an election where a new DA could come in and say, I want to pursue this. And again, with the potential of deposition testimony in the civil case, there is that potential.
Would this apply, your interpretation apply to automobiles used in a crime where nobody's been charged yet? Did the county just hold a motor vehicle for years and years and years? It says weapon, instrument, appliance, or substance. Just there's ramifications of your argument that the county can hold somebody's property. Here, do they need a gun? I don't know, they got 30 other ones. Not the end of the world if they only have 29 guns, but it could be a more significant deprivation if it's a motor vehicle or something of value, more value.
I understand your point. And I think I didn't think of it from that perspective. I'd have to think about it a little bit more, but I understand your point. I wanted to make one other point as far as the petitioner's brief. He relied on a St. Lawrence County case for the proposition that essentially the DA's office may be filing a criminal complaint and the property was held for an unreasonable amount of time. First, that case that he cited was reversed by the third department. The citation there is 110-83D 1297. And second, that case didn't involve a gun. And so I don't think that that's relevant to our analysis here.
All right. Thank you very much.
Thank you.
May it please the court, John Manier on behalf of the respondents, Sean and Riley Mahoney. Your Honor, I'm going to jump right into it. You hit on the exact example that I was going to use. If a vehicle is being driven and person A is the driver and it hits and strikes and kills person B, well, according to the appellants, they can hold that vehicle forever because it was used in the commission of an offense.
Even if someone just in the vehicle shoots somebody.
That's exactly right. And then they're deprived of a piece of property that they own and have a possessory interest in. The key factor to take away from penal law section 400.05 subsection 1 is used in the commission of an offense. Commission of an offense only attaches when there is chargeable criminal conduct where that criminal conduct is applied to each and every element of an offense and is attached to a criminal instrument, a charging instrument.
So until sometimes it takes a week or two to file a felony complaint.
Sure.
Before then, the gun has to be returned?
No.
Because charges aren't filed yet.
It was surrendered to law enforcement.
Yeah.
And just like the case that was cited in our brief, it was surrendered to law enforcement. There were receipts given to the party for that property, and it was held during the investigation. And that's what the purpose of this is. A determination of a commission of offense. Again, it doesn't just exist in our heads. This person committed an offense, therefore it was utilized in the offense. That's not the standard. You can't just deprive someone of a piece of property that they have a ownership interest in. That's a violation of our constitutional rights. I mean, everyone is aware of that standing here today, but you can't do that. There has to be some official conduct or some charging instrument alleging that criminal conduct.
There's some burden, in other words, on the official declaring it a nuisance.
That's exactly correct. And
they haven't, no matter where their burden is, your positions, they haven't hit any of it, even if it's a low bar. They haven't presented it to a grand jury. It hasn't been a charge or accusatory instrument or anything, let alone a conviction.
That's it, Justice Delconte. In a nutshell, that's it. They haven't done any. They've investigated for over a year.
It's been 2.5 years.
2.5 years. We're going on 3 years, Judge.
Yes, 2.5. Well, if it were 2.5 weeks, probably a different story.
Very well, yes. And
there's some time between 2.5 weeks and 2.5 years where they got to give it a gun back, in your view.
So setting a time period is a whole different story. I would respectfully request the court not to set a time period. But what we have here is a clear determination of 3 years, almost 3 years, and nothing.
What is this civil trial? Is that ongoing right now?
It is. It's still pending. But here's the facts.
But when is that going to be over? Because it sounds like that's what they're saying. Let's just find out what happens at the civil trial, then we'll give you the gun back if need be. Is that anywhere close to being over?
It is not. But the fact remains, Your Honor hit the nail on the head with regard to this is a firearm that they've had in their possession for 2.5+ years, correct? And they can photo it, they can shoot it, they can recreate it with a 3D printer. They don't need this firearm. There's no opposition or there's no dispute that this was the firearm that was used in this terrible incident. There's no dispute.
And I'm sorry, Counselor, but you have your client has an obligation to speak up within a year.
And that's exactly correct.
If you waited 2.5 years to bring your petition, the gun might have been destroyed.
In fact,
before the expiration of a year, you have to make this application.
We absolutely have to. Under Penal Law 400.05, subsection 6, this is right on point to what we needed to do. And in fact, we surrendered, and the language of the statute is clear. A firearm or other weapon which is surrendered has not been declared a nuisance, and we don't have that here. There's no lower court that has declared this weapon to be a nuisance. Again, under 400.01 or 05. Subsection 1 has to be used in the commission of offense. We don't have that here. Shall be retained by the official to whom it was delivered for a period not to exceed 1 year. Prior to the expiration of such term, and this is where Justice Delconte was going, a person who surrenders a firearm shall have the right to arrange for the transfer of such firearm to himself. If it doesn't happen within that 1 year period, I've cited the case that stands for the proposition. Here's 7 years that go by since those firearms were surrendered. The court held the plaintiff's possessory right or interest in the pistols, which came into defendant's possession pursuant to Penal Law section 400.05 subsection 6, was extinguished by his failure to reclaim them within 1 year as required by the statute.
Counsel, forgive me if I missed this in the brief of the record, but that was from the June 3rd, 2005 decision from Judge Fuller, right?
No, the case I just cited to was from
That's what he relied on.
the Judge Bowler just indicated in his order that he's ordering the return of the firearm and that the petition was granted in all respects.
I understand. But that was June 3rd, 2005, right?
2025.
2025. I apologize. It's right here. How has it stayed since then? It wasn't returned in 2025 and it's in your client's possession, right? It's still being held.
We don't have it, and it's still being held by either the district attorney's office or the sheriff's department.
Is there a stay in
Was
effect?
there a stay?
There was never a stay that was imposed. My understanding was that there was an automatic stay as a result of the state entity, the.
All right, so there was a stay. There was a stay, not a stay
Right.
application.
Correct. That's my understanding.
I think we understand the argument.
Judge, I'd ask the court to affirm the decision in its entirety. Thank you.
Thank you. Case 519 is in the matter of the estate of Russell J. Solomon versus, nope, that's just it. The matter of the estate of Russell J. Solomon, case 519.
Good afternoon. May it please the court. I'm David Sealing on behalf of the appellants. Only 4 years ago, this court upheld a surrogate's decision ratifying the sale of specifically devised real property on the basis that the specific devisees had consented. Only 4 weeks ago, the Second Department had a similar decision relying on Elmfield, in which they also determined the issue on the basis of consent. This case presents the clean question of law of whether specifically devised real property, which vests absolutely in the devisees at the moment of death, whether those rights can be taken away without leave of the court or consent.
Can I just get to the factual issues here? The decedent had more debt than assets, right?
Correct.
Are you suggesting that if the executor, if the property went to your clients directly, they could have kept that property or sold it and kept that money and the estate's debts are unpaid?
No, they would be in a position to redeem, likened unto a redemption.
So the money from the house, if it went to your clients, that would have gone to satisfy the decedent's debts, the estate's debts, right?
May I ask to clarify, whether they sold it or not, wherever the proceeds may never have happened. They might live there today, but for the decision of the executor to transfer it in excess of her authority.
Right. But I guess my point is, under any circumstance, would your client have gotten any money from this estate?
Entirely possible.
How so?
No, from the estate, no, but from the property, quite possibly. The property was sold only a short time later for substantially more money. But the practical reality of that sets aside the legal rule set by this court in Ellenfield that something is necessary prior to an executor acting outside of authority, which was found below. The findings below are that there was no consent. The findings are that the executor lacked authority to make that transfer.
The court did it non-pro-tonque.
Correct, Your Honor. Yeah. And that was done here in Ellenfield on the basis of consent. And this case poses a question, what if they don't? What if they're never asked? What if instead of, like in Riney, recently decided in the Second Department, 20 years go by, and then we have a case. This property was transferred in advance of any passage of time. This was the contract for sale predates the letters testamentary. The contract
wasn't signed till afterwards, though, right?
Not by both parties.
So we don't have a contract until then.
Correct. Our argument is set forth in our brief is that those factual findings that the executor lacked authority, that there was no consent, and that the proper procedure to obtain authority to sell that property were not followed.
Well, there weren't any assets to pay for the expenses of the estate.
There were some limited assets.
10,000 and the assets were like 10, expenses were over 25.
That sounds correct, Your Honor.
So you're a little deficient there. So who's going to make up that difference? And they have priority. Those assets funeral expenses, et cetera, they have priority here. And who's going to pay those?
Well, an estate's debts and assets are determined at the point of judicial settlement. At judicial settlement, had the specific devisees been advised of their rights in a proceeding pursuant to 1902, it would have been dealt with in advance of the sale. They would have had their moment to speak now, forever hold their peace. As such, the moment should have been at the point of judicial settlement.
They were never involved before, right? I mean, yeah, the cleanup was done by the executor. The work was basically done by the executor. I think Bridget helped a little bit in cleaning it up. An offer came in, and it had to be sold.
With respect, that goes further than Ellenfield in kind of deeming their lack of involvement some sort of acquiescence. And Ellenfield doesn't go that far.
They were involved until they were asked for consent for the transaction, because of the fact that there was no consent given. There was no consent given for the original sale to the purchaser who bought it for $115.
That's correct, Your Honor.
Not until then is when, oh, wow. And they had a copy of the will. They were given the will right away. They knew they were specific beneficiaries of this specific piece of property, specific devisee. Nothing. They didn't do anything until they were asked for the consent. And after they made all these improvements to the property, the purchaser of the 115 made all these improvements of $275,000 in there. Now, basically, your clients are coming forward and say, well, I want this house. This is my house. Thank you for making all these improvements to this house. I'm very grateful.
And there may well be claims that go back and forth when this matter is returned below about that kind of enrichment and who was liable for what. However, there is no requirement under common law as abrogated by the statutory framework we have, which poses an affirmative duty on a specific devisee to come forward unilaterally and address within a few months of death the issue of the decedent's debt. You'll note in the record, there's $42,000.
Edenfeld, I'm correct on this, didn't the beneficiaries say next day, when are you going to sell this property?
I didn't hear you, Your Honor.
Wasn't there a situation where the specific devisee in that particular case indicated within a day or so to the executor, when are you going to sell this property?
That is not something I read in the record.
He's talking about Ellenfeld, I believe.
Yeah.
Ellenfield. Oh, yes. And then they consented to the sale. And this court's been cited in that decision in many other contexts for the principle that an email by attorneys can constitute affirmative consent. So
we don't have that. In your view, we don't have the consent that they had there, or the evidence is weaker, and these are not good faith purchasers. They should have known that something was up here. So we will take a good long look at all those issues.
Thank you.
Thank you.
Good afternoon, Your Honors. J. Michael Lennon from Roach, Lennon and Brown on behalf of the Vanderwall respondents. They're the purchasers of the property. And during the argument, the appellant's counsel referred to the Ellenfield case. And one problem that I've had, I wasn't trial counsel in surrogate's court for this, so I came at it a little bit more objectively. One problem I always had is it seemed to me that the appellants continue to make the argument that because their interest specifically vests, or their interest vests at the time of death, they have almost like this veto power over anything. And I think they continually overlook a key point, and it's right in Ellenfeld that yes, the interest vests at death, but it's subject to the executor's power under the will to sell the real property to satisfy the estate's debts and obligations.
The will said pay debts first.
It did.
Now, what if the will said pay my debts last? Then what?
If that had been the case, then I think we'd still, you'd have to look at the will. You'd have to see what the order was. But ultimately, under Article 19 of the SCPA, the executor still has that authority. If the estate is insolvent, and that's undisputed here, and again, in talking about what's undisputed, I think I also should point out, which I suppose this court is aware, is that the credibility judgments of the surrogate court judge are entitled to great weight on this appeal. And the only two people that testified at this hearing were one of my clients, Mrs. Vanderwall, and the executrix. And so the appellants had the opportunity to testify had they wanted to, and they chose not to. So there was no ability for the court to make a credibility assessment about anybody other than the people that were involved in this transaction. And in terms of the other piece of the puzzle here, I think that wasn't addressed in the appellant's portion of the argument relates to that issue of bona fide purchaser status for my client. So even if this court decides that the surrogate court didn't have the authority to do what they did non-pro-tunc, my clients are still protected as bona fide.
That's a second hurdle they have to get over. He's got arguments as to why they weren't, given this, it wasn't listed on the multiple listing service. They just showed up and seems a little fishy, but we understand that there's two birds they got to get over.
Understood, Your Honor. And I think that just in terms of the characterization of the deal, this characterization of being some sort of a driveway handshake deal, yes, these two parties did meet in a driveway in a small town of Cuba, New York, where property goes up for sale or a property is under construction or a property is being cleaned out. Folks are going to notice. But there was a period of time then after that, before the contract was in place, the executrix was vested with authority at that time. She had gotten preliminary letters issued in September. Full letters were issued in November. She didn't sign the contract until December.
There's no self-dealing by the executrix. She's just trying to pay the debts.
Correct, Your Honor.
Wasn't trying to line her own pockets.
Absolutely.
All right,
Correct.
thank you very much.
Thank you.
We'll go to case 520, Hoskins versus Hoskins, case 520.
Good afternoon, Your Honors. If it please the court, Anthony Adams appearing for the appellants and the plaintiffs. I think that with respect, the issue in this case is whether the defendants met their burden of overcoming the prima facie case that the plaintiff's shareholders made here, that they're entitled to distributions.
This is a little like the case we just heard, where county has the gun for years. They have your client's money for years. At some point, it's got to be turned over. And I know there's this environmental issue with some potential liability, but how many years have we gone since this distribution was initially supposed to be made? Remind me again.
Your Honor, the property is supposedly was sold in 2015 and sometime according to the affidavit shortly after that.
And there were some representations that's coming, the text is going to be
That
right
was,
there.
that would say 2016, this agreement, whatever this agreement is, was made. And it's now the reason that they can't distribute funds. But in 2017, 2018, 2019, representations were made by the defendant's representatives that distributions were coming. 2020, when counsel for the defendant sent an email and saying, hey, we got this environmental concern and contingent environmental concern, but it'll be over a year and a half. So don't do anything for a year and a half. That was I think it was in May of 2020. In July of 2020, that's when the text message comes from the defendant himself to my client that says, hey, that money that we're holding, half of it's yours, I figured out a way to distribute it. Now that's all in the record, and none of that's rebutted. None of that's rebutted. 4 million, I don't think there could be any dispute that on this motion for summary judgment, we made a prima facie case.
Can I ask you about this settlement agreement that they say is it's this confidential settlement agreement?
Right.
And that's why we can't release the money.
Right.
Was there a request for the court to look at the settlement agreement in camera? I mean, I don't get what the big secret is, first of all. I mean, we know who the party is. We know where the property is. I don't get why nobody in the world can know about it, but let's assume that that's legit. Did you say to the judge, can you please just look at it to make sure that this document exists?
I didn't make that request, Your Honor. I made my motion, and in response, I didn't get such a request that the judge reviewed in camera. In fact, I complained in my response that why didn't they submit it for in-camera review? Why don't they give us something instead of just like a conclusory statement that take our word for it, there's a contingent liability out there, and we're gonna just make distributions once that's done. Who knows when that'll be? Again, this is when they haven't denied, saying one thing we said was, my client said in her affidavit was, my brother has repeatedly offered to make distributions if I'll give him a release. He didn't deny that. So it's obvious that that's not the reason he's not making distributions.
Well, it would be a legitimate reason to hold off if there's potential environmental liability.
Well, Your Honor,
we just
respectfully.
don't know if that's, you question whether that's true.
No, that's not that. It's not that. There's a second cause of action in this complaint, which is not before you right now, which is against the same defendant for his conduct in connection with some limited liability companies that were owned, that and particularly a transaction that occurred back in 2014, 2015. We got claims related to that. Now those, so that's, I mean, that would have had to be released as well, I presume, if we're looking for a general release. This is strictly a point of civil procedure as far as I'm concerned. We made a motion for summary judgment. We made our prima facie case. They didn't rebut it. We should have gotten judgment directing distributions.
Thank you.
Good afternoon, Your Honors. May it please the court, James Milbrand, Barclay Damon for John T. Hoskins. Judge Lindley, you hit the nail on the head, right? Why hasn't he distributed it? Well, there is a contingent environmental liability. What Mr. Adams didn't let you know just now is he has that agreement. That's been handed over in discovery. The posture of this motion and this case is for summary judgment with no discovery being conducted. Zero. Now, last week, Mr. Adams made a motion to sever this claim, which was granted by Judge Chimes. Now we're moving forward. Now he has discovery. We sent a bunch over last week. He now knows that there is a real potential claim. We pray and hope that HS 570 doesn't have to give up $4 million to Rich Products.
When will we know if there's going to be is there an end date where we can sure she's going to get the money? If there's no liability.
As soon as the New York State Department of Environmental and Conservation gives it a clean bill of health.
Do we have an estimate of?
I ask every week.
So your client can't get his money either.
Exactly. And I'm sorry.
Who's getting the benefit of this, the value of this money? It's being in escrow.
It's been invested, it's gained.
So eventually, if there's no liability, she'll benefit from the increased value. Right?
Absolutely, Your Honor. And so will my client. Right. But you have to look at the business judgment rule. I think Judge Chimes nailed it on the head in two statements. Here, through the affidavit of John T. Hoskins, defendants assert that the failure to distribute is due to potential liability for an environmental cleanup of properties sold by HS 570. Plaintiff failed to submit any evidence to suggest the decision was fraudulent or in bad faith. We don't want the court stepping into the boardroom and deciding things for companies.
There's no insurance for that.
We're seeking insurance, Your Honor. We're seeking insurance for the lawsuit from Beth against the directors. We're seeking.
No, I'm talking about for the environmental.
For the environmental, no. What happened was, and I am bound by confidentiality on it, whether or not I like it, but the agreement was entered with Genesis, an offshoot of Rich Products, and a certain amount of money was paid as consideration on that agreement from HS 570. As long as the cleanup doesn't go over another amount, then we're free and clear.
Okay.
But if it goes over that amount, then Rich can come after us for additional.
So the DEC is going through there, they're digging up, they're testing, this has all been continuously going on.
Yes, Your Honor. And it's moved at each stage. I'm not an environmental lawyer. Jeffrey Stravino at Hodgson House is an excellent environmental lawyer, and he's handling it. And I email him, call him at least twice a month.
Right. Your client wants this release as much as Beth does.
Absolutely. And very importantly, Your Honor, I don't want to be back in front of this court with Rich Products trying to pierce the corporate veil and hold my client and his client liable. So the distribution's not going to be dumping every penny out in 2 minutes. It's going to be a methodical wind down of the company as the law has established to avoid the piercing of the corporate veil and show it has valid reasons. I can't have my client distribute or I'd be committing malpractice.
Thank you very much.
Thank you.
Last case on the calendar is 522 Thomas J. Dickey versus Jacob Robert Prevost.
Oh, Your Honor, the Yankees said last night that it way too soon to say.
Yeah, I apologize to you and all the Sabres fans.
Good afternoon, Your Honors, and may it please the court. My name is Chris Borgatti, I'm an attorney with the appellant Maxwell Murphy in this matter. Preliminarily, I'm sorry we have to be here on this matter. We've tried to resolve this and done all that we can. But here we are. I've submitted papers and I will endeavor to be brief and answer any questions that you may have. It's the appellant's position here that the lower court erred in awarding a referral fee where it is our position that a full fee on our contingent arrangement should have been paid. Here, two licensed attorneys agree that a $500,000 offer was made to the appellant on December 1st, 2023 to settle this matter.
They seem to disagree on that 500 figure. They seem to think it was 450.
So, as I was saying, two licensed attorneys, officers of this court testified under oath.
Right.
Well, one did, including the attorney that effectuated the settlement, the mediator, agree that there's a $500,000 offer on December 1st, 2023, which is.
And eventually settles for 6.
It eventually settles for 6 about 3 months later.
Right. So your point is your firm had or your client's firm had the case for 2+ years. They had it for 3 months. And if anything, those percentages should be swapped based on it's not just the time, but the work that went into it, in your view.
100%. And whether this court or the lower court looked at it as quantum merit or contingent, the result is the same here. Any fee apportionment should be proportional to the share of work performed on the case, plus the amount recovered to the work completed. Quantum merit.
Can we just do that ourselves? We know the fee is 200. It's got to be whacked up unless we affirm. Do we have to send it down if we don't agree with the judges? The judge seemed to say a third of a third here, which is the referral fee.
Right.
And you say this isn't a referral. This is, we worked on it. The referral is we just hand you and you do all the work. So if we agree with you that a third of the third isn't the right formula, can we just apply the right formula and come up with a dollar amount, or do we need to remit and have the judge make new findings?
I can't answer as a matter of fact, but what I can tell you is based off my understanding of the case law in this matter, you can make that decision. And this case has already went through a quantum merit hearing.
Is Judge Stadita retired?
I don't believe he's retired.
Okay.
The most important part for this court to look at is that the best time to look at when the contributions of an attorney or a firm on a case is at the end of the case. It's very clear the timeline at what point in time the case is worth a certain value. And I would argue that you can make that determination, and you should make that determination.
I think we understand.
Okay.
Thank you very much. Mr. Collins, good afternoon.
Good afternoon, Your Honor. May it please the court. I am Dylan Collins. I represent Collins & Collins, and I'm also an attorney for Collins & Collins. First and foremost, what I would like to address is the notion of a referral fee. I don't think that is a proper language at all. There was a motion made to apportion attorney fees. As a result of that motion, a quantum merit hearing was held. I don't know how that turns into a referral fee. I believe that is a finding in quantum merit on what is owed.
Right.
And
so maybe the number the judge came up with is the same amount that it would be if it was a third of a third referral.
yes, but
But it doesn't mean that that's how he got to that number.
exactly. And, he got to that number, and I believe Judge Shadida put it on the record well using Kennedy, which was decided by this court. In Kennedy, there's multiple factors, which includes stuff like the contingent agreement, but it includes time spent. It includes the nature and complexity of litigation. It includes the attorney's experience, ability, reputation. And he went through each factor on the record and put his opinion on the record.
And then he drew the conclusion that this is a traditional third for third. He didn't really, I mean, he may have walked through those factors, but did he apply those factors? That's the petitioner's argument here.
Exactly. And my argument is that he did apply those factors. I think the petitioner in their brief and in their argument, their strongest point they make is the amount of time each firm had the case. I would just like to point out, and I know it is pointed out in the brief, the appellant was retained in August 2020. Pleadings on the case were filed about 1.2 years in October 2021, and discovery wasn't furnished until January 2023.
Right. I don't think anyone is on the panel was just going to look at a clock and say who had the case for longer and is the work that was done. So what would you say that Collins and Collins did that as compared to Maxwell Murphy? Maxwell Murphy files, they get the client in, they file the complaint, they do some depositions, and they have what did Collins and Collins do besides settle it?
Yes, Your Honor. So Collins and Collins, I think, first and foremost, I think the biggest factor besides settling the case for an increased value is they managed the client and the client's expectations. The client was not happy with Maxwell Murphy's representation, which is why they sought new counsel in the first place. The alleged offer amount is not agreed between me and the opposition here.
There's an email on the record.
Exactly. And that email on the record is dated 5 days after
from the mediator.
From the mediator. And I would just like to put on this record that email is from the mediator to Maxwell Murphy, basically stating, hey, the offer's been increased. It wasn't Maxwell Murphy reaching out to the mediator.
Let me ask you a question. As I read your brief, it seems to me that you disagree with this premise that quantum merit is not just hours times fee. Quantum merit doesn't have to be the lodestar application. Do you agree with me on that?
I agree that it's not just hours time. I think it's all the factors.
So when the senior partner takes this file and says, I'm only going to take this file if you clients agree that this is going to be transferred to us and your outgoing attorney has to be paid on a quantum merit basis, he understood at that time that it could be an allocation of the contingency, not based on the lodestar method, hours worked times a rate.
Well, I can't put words in his mouth, but he understood at that time that he took the case because the client informed the discharge counsel to be paid in quantum merit. So
you don't disagree, though, that the senior partner didn't take it on a referral agreement at that time, a third of a third. He wasn't
took it on quantum merit.
Right. He wasn't expecting yet a third of a third when he said to the clients, your former attorney is going to be paid on a quantum merit basis.
Well, he doesn't know what he was expecting because at the time he didn't even know what it would settle for. I believe, though, that just because.
Well, let me continue with this because you're understanding. If your principal convinced the Dickies to pay on a quantum merit basis, and let's assume the case went to trial and the Dickies got nothing, Maxwell would be entitled to a fee, wouldn't they?
Yeah, based on.
They would have to pay the quantum merit basis of what the value of Murphy Maxwell's work was at the time they discharged them.
Yes, correct.
Right. And that was done, that arrangement was done really at the advice of your principal.
Yes, it was done because he thought in order to, litigate this case and conclude this case, that would be the only way he'd be able to take it.
So he spent about a month and a half or maybe 2 months and he went to a mediation and settled the case. That's what happened.
Not time-wise, he spent 3 months, and within that 3 months, we tried to obtain the file from Maxwell Murphy. They gave us an amount which I believe was around $1,600 and change for disbursements. We paid the disbursements. We never received the file till 9 months after it was settled. So within that 3 months, we had to rebuild the file using public filings on NICEF from opposing counsel, order our own medical records, and files that the plaintiff had in their own possession.
Can I ask you this? Do you think in determining quantum merit for what Maxwell Murphy should get, is it relevant the work that Collins and Collins did vis-a-vis Maxwell Murphy? Do we compare efforts, or is what Collins and Collins did for those 3 months irrelevant to what Maxwell Murphy gets?
I think that in determining what Maxwell Murphy receives in quantum merit, I think what's relevant is what they completed on the file.
Isn't there a possibility that Maxwell Murphy could receive in quantum merit a greater amount than what Justice Sedita decided?
Yeah, I'm not sure I understand the question. Justice Sedita's decided the 1/3 in quantum merit.
64,000 or something like that.
Yeah, it was 66,000 minus the disbursement check.
If actual quantum merit, another quantum merit was done, if we send it down and ask the judge to reevaluate everything, and isn't there a possibility that allocation or distribution could be greater than 64,000?
Yeah, that is a possibility. My position and Collins's position is we believe Justice Sedita weighed out all the factors, put it on the record, and we think his decision should be affirmed.
Thank you, counsel.